Hello and thanks for staying with us. Welcome to a special program, Presidential Election Petition Judgment. It is a simulcast as our sister radio station, Repa FM, is hooked up to this transmission. My name is Amechi Anapwe, and I'm joined by my colleague, Ijoma Osamu.
Well, it's good to be here, and the program today will be all about the judgment of the Presidential Election Petition Tribunal, expected to be delivered this Wednesday.
We will start with pre-judgment analysis, then we will bring to you live the judgment as to be delivered by the 5-member panel of the justices of the tribunal, and after that, the much anticipated judgment has been delivered. We shall continue with post-judgment analysis.
So this promises to be a very important day in Nigeria's democratic and electoral process, and will ensure that you don't miss any of the actions. We will have to take some little break here so that we can have one or two. So let's quickly look at what is going to happen today. There's so much apprehension, there's so much expectations from the both persons who are supposed to be at the center of this judgment today.
Expectations from the two parties at the center of it all. The two candidates, talking of APC and PDP, Muhammad Buhari and Atiku Abubakar, and expectations from Nigerians and the rest of the world is the judgment today, and subsequently the one that will come from the Supreme Court is one that will help to define and redefine Nigeria's electoral process and as well our democratic process.
The fear has always been that there's never a moment in Nigeria where a sitting president will be taken out through the tribunal or through the court. We've never had that kind of experience. It seems today we'll be expecting a lot. We want to know where it will sink to.
That's the big question, and that's the question the 5-member panel of the Election Petition Tribunal for the presidential election would be trying to resolve by the end of the day. How long is it going to be? We don't know for certainty. It could stretch for hours. We told you earlier, pre-judgment analysis here. Judgment itself, live feed from the Court of Appeal complex venue of the Presidential Election Petition Tribunal judgment, expected to commence in a few minutes' time. And so we'll also be taking you live even before then to the premises for our correspondent Utibe Omoren to fill us in with the atmosphere at that venue.
There's no camera that will be on them. Okay, that's all you get. Okay. That's all you.
And a lot of them expecting the judges to arrive.
Yes, I saw those at the court rise. Possibly it's possible. The court, I think the processes have commenced as soon as we establish the audio connection.
Hello. So this camera, please cut down your eye, please. You show your highlights and it's appearing on the screen. So from the look of things, pull out more. Yes.
I represent People's Democratic Party, Prince Richard Second.
So it's like this one is really...
May it please my lords.
Just a moment. Yes.
May it please my lords, Mrs. May Agbamuchembu, INEC National Commissioner and Chair Legal Services, for the first respondent.
Yes.
With due respect, my lord, my name is Honorable Wakili Saki, representing President Muhammad Buhari, the second respondent.
Yes.
We profound respect, my lord. My name is Adams Aliyu Oshomole, National Chairman, All Progressive Congress, representing the All Progressive Congress.
Yes, appearances. Those up.
With due respect, my lords, Dr. Levi Usoku for the petitioners. Appearing with me are my brothers Silk, KCO Njemanze, Chief Mike Ozekome, Emeka B. Etiaba, Chief Godly Uche, Dr. Mrs. V.J. O. Azinge, Emeka Okoko, A.K. Ajibade, and our brothers of the outer bar, starting with Emmanuel Inoidem, Ahmed T. O.S., Alexander O. Ejesieme, Abdulaziz Ibrahim, Chike Okafo, Chikama Keshetu, Jabiru Bashir Mohammed, Salas Joseph Onu, and finally Jude Daniel Odi. May it please my lords.
Yes, Mr. Wagi Usman.
With the greatest respect to your lordships, Yunus Ustaz Usman,
Yes.
O.A. Omonwa S.A.N., Sam Toby Ologun Orisha S.A.N., Tenimu M. Inua S.A.N. With us, my lords, are our learned friends, Abraham Madaki, B.M. Salihu, Mohammed Ibrahim Tola, Udu Diegbe, S.O. Ibrahim,
And all the others. whose name have been ticked on the list of council.
My Lord, because
More than 40 of you.
some of us who are old will not have the opportunity of meeting all my lords again now. Well, we agree, my lords. It's a long list, but my lords are all here.
All right.
My lords are grateful.
Yes.
My Lord, with profound respect to my Lord, my name is Professor Taiwo or Petition. I announce appearance for the second respondents with my brothers of the Inaba,
Yes.
Osaro Egobiamen, Ken Moza, Dayo Akinlaja, Nanso Ekanem, Chief Olushola Oke, and the last but not least, Akin Oshibaju. My Lord, today being the judgment day, may I plead that we depart from the rule by also announcing some of our colleagues who are here and whose names have been ticked. I'd like to start with number 16. I know O Salami. Next is Ogbenero Ide. Mrs. Boma Alabi. Dako Akin Oshun, that's number 21. Number 24 is Edwin Anikwe. We also have with us number 27, Adeshino Agbede. Number 29, Jide Adejan.
Prof.
Sir.
Like the first respondent.
Oh.
You have to really read out all the names that are here.
You
have more than 60 of them.
No, not all of them. Not all of them.
But you have mentioned some.
Yes, sir. Madam, may I stop them with the additional Agbede?
All right. All of them are in course.
Yes, sir.
All right.
Well, very grateful, sir.
Yes, Prince Fagbemi.
Very much obliged, my lords. Most humbly, L.O. Fagbemi, with my learned friends of the inner bar, that is, Chief Charles Edosonwan, Chief Adeni Akintola, Chief Bembela Anachebe,
Yes.
Chief Oladipo Okpesheyi,
Yes.
Malam YC Mekel, Malam Ibrahim Bawa, Dr. Chief Muiz Banire, and Malam Nasser A. Dangiri.
All right.
We have our learned friends. My lord, it's a full court and a long list. From number 13, that is to say Nicholas Akintola Ladapo. I'll just crave your indulgence that after Akinola Deji, I made an omission and I apologize. We have Ibrahim Shafi.
After number what?
My lords, after number Akinola Deji, just shortly, before Tunde Ogala, number 14, he should come as number 15. Otherwise, my lords, everybody is present and available.
All right.
I'm very much obliged. We are appearing for the third respondent. I'm sorry, I know I'm not appearing for the second respondent, but specifically when we received hearing notice yesterday, I got in touch with him. He's in faraway Europe, and he said that I should specially convey his apology that he didn't know that the matter will be coming up today, and it's a bit difficult for him to make it. Thank you, my lords.
Gentlemen, you remember that on the 21st of August, when the parties adopted their final addresses in respect of this petition, the court indicated that judgment would be delivered on a date to be sent to the learned senior and other counsel for the parties. Now that day is today, and here you are. You also recall that during the pre-hearing session, certain applications were taken, which were argued and ruling reserved to be delivered at the final judgment stage, which is today, in line with both the Constitution as well as the provisions of the first schedule to the Electoral Act. We shall, before delivering the final judgment, deliver rulings in respect of the said applications. I will start with the first respondent's motion, which was filed on the 5th of May, 2019. And by the said, this is the leading ruling in respect of that motion. By the said motion filed on the 5th of May, 2019, the first respondent prays for, and I quote, an order of this honorable court, striking out the petition dated 18th of March 2019, the petitioners having failed to join the vice presidential candidate of the All Progressive Congress, Professor Yemi Osinbajo, SAN, GCON, a co-winner of the 2019 presidential election, who is a necessary party in this petition, end of quote. There are 4 grounds upon which this prayer is predicated, and I set them out in the ruling. The application was supported by a 5-paragraph affidavit and a written address. As is to be expected, the petitioners opposed this application by filing a counter affidavit of 15 paragraphs, attached to which is a written address opposing the grant of this application. The said processes were duly adopted by the Learned Senior Counsel for the parties on the 11th of June 2019. And the thrust of the Senior Learning Council's argument on behalf of the first respondent are that one, that the Vice President, Professor Yemi Osunbajo, SA and GCON, is an indispensable party in this petition, and that his right to fair hearing would be breached if the petition should be determined in his absence, thus violating the provisions of Section 36 of the 1999 Constitution as amended. Two, that a combined reading of Section 133 and 137(2) of the Electoral Act makes the Vice President an indispensable party and not merely a desirable party. Three, that if it is found that Section 137(2) of the Electoral Act, which talks of a person, will mean singular, then Learned Silk urged the court to declare it void to the extent of its inconsistency with the Constitution. And four, that failure to join the Vice President robs this court of jurisdiction to advocate on the petition, which, and he relied for these reasons on so many cases which are set out, including Okolugo and Ise. Citations of all are set out in the application, and he ordered us to grant the application. And after a reading of consideration of all the submissions by Learned Senior Counsel in support of the application, I go on to now deal with the merits of the issue conversed in this petition. It is imperative that an election petition which is generous and governed strictly by the Constitution of the Federal Republic of Nigeria and the Electoral Act, that parties comply with the provisions set out therefore. Non-compliance with the said law, the commencement or institution of an election petition is not a mere technical rule or irregularity, but it goes to the jurisdiction of the court and robs the court of the jurisdiction because it goes to the root of the petition. I refer to the case of Buhari and Duku, citation of which is set out in the ruling. So election is neither seen as valid as a civil proceeding in the ordinary sense, nor, of course, a criminal proceeding. It can be regarded as a proceeding sui generis. It is imperative that in the present position that the procedure laid down in the Act be strictly complied with, except to the extent that it is relaxed or waived under paragraph 49(1) of the first schedule to the Act. Section 131(2) of the Act requires that the person elected or returned be joined as a party. Section 133, which I earlier reproduced, provides in subsection 1 for persons who may present an election petition. Now, the vocal contention of the first respondent is that Professor Yemi Osunbajo, SA and GCON, as the vice presidential candidate, was the co-winner with the second respondent, whose right to fair hearing would be contravened in violation of Section 36 of the Constitution of Nigeria 1999 as amended, and that the vice presidential candidate is a necessary party to this petition. One may then ask, who is the necessary party within the context of the Constitution and the law governing presidential petition? In this case, in this vein, recourse must be had to Section 239(1)(a) of the Constitution of the Federal Republic of Nigeria aforesaid, which provides, and I quote, subject to the provisions of the Constitution, the Court of Appeal shall, to the exclusion of all other courts of law in Nigeria, have original jurisdiction here and determine any question as to whether, A, any person has been validly elected to the office of the President or Vice President under this Constitution, end of quote. Then Section 137 of the Electoral Act as amended provides as follows, and I quote again. 1. An election may be presented by one or more of the following persons. A candidate in an election. B, a political party which participated in the election. Subsection 2, a person whose election is complained of in this act refers to as the respondent. And 3, if the petitioner complains of the conduct of an electoral officer, a presiding officer, a returning officer, it shall not be necessary to join such officer or officers or persons, notwithstanding the nature of the complaint, and the commission shall in the instance be made a respondent and deemed to be defending the petition for itself and on behalf of the officers or such other persons. The above provisions of the Constitution and the Electoral Act have been judicially considered and applied in several cases, among which is Buhari and INEC, citation of which is set out. There's also Faleke and INEC, citation of also which is set out. Yaya Bello, ADC and Yaya Bello, citation of also of which is set out. Now, the count reading of Section 239(1)(a) of the Constitution of the Federal Republic of Nigeria show that Professor Yemi Osinbajo, SAN, TCON, is an interested party in an election challenging the return of the second respondent by INEC in the presidential election which held on the 23rd of February 2019. However, since the second respondent who nominated him as his running mate is a statutory respondent to the petition, and the third respondent who sponsored the second respondent and the vice presidential candidate are parties before this court as second and third respondent, the non-joinder of the vice presidential candidate would not render the petition as constituted with regard to parties incompetent. The second and third respondents are his principals. The petition can conveniently, efficiently, competently be adjudicated upon by this court in the absence of the vice presidential candidate. We refer to the case of Kalu and Uzo, a decision of the Court of Appeal, a decision of the Supreme Court in 2004, where Adeke, JC now said, JS said, as I mentioned earlier, on adequate provision must surely be made for major steps in the Constitution and the Electoral Act 2002 itself. Section 187(1) of the Constitution of the 1999 Constitution provides as follows. In an election to which the foregoing provisions of this part of this chapter relate, a candidate for the office of the governor shall not be deemed to have been duly validly nominated for such office unless he nominates another candidate as his associate for his running for the office of governor, who is to occupy the office of deputy governor. And that candidate shall be deemed to have been duly elected to the office of deputy governor if the candidate who nominated him is duly elected as governor in accordance with the said provisions. From the words above, no one is left in doubt that the actual candidate at the election is the governorship candidate who, in fulfillment of the Constitution, nominates the deputy governor. Another further is whether the deputy governor falls within the definition of the word candidate as envisaged by Section 133(1)(a). There is a difference between the actual candidate who contested an election as governor and the other candidate whom the Constitution places in the shadow as an appendage. As is described in decided cases, both governor and deputy governor stand and fall together. PDP and another, INEC, 1999, 11 NWLR, Part 626, page 200 at 249. A deputy governor is envisaged as an interested party in the circumstances of this case, and not a necessary party. Necessary parties to an election are those covered by Section 133(1) and 133(2) of the Electoral Act. A necessary party is defined as one whose participation in the proceeding is indispensable, whereas an indispensable party is one without whose presence no adequate judgment can be entered determining the rights of the parties before a court. It is a person who has an interest in the controversy that the court cannot render a final decree without affecting their interests. It is a person who must be joined because non-joinder prejudices his rights and those of the parties already joined, such that the action cannot be continued without him. In this appeal, the Deputy Governor to the appellant and the first respondent are surely not indispensable parties. Buhari and Yusuf, 2003-14 NWLR, Part 841, page 446, Abubakar and INEC, 2004, 1 NWLR, Part 5, 854, at page 207, Uzojima and Udenwa, 2001, 1 Nigeria Weekly Law Report, Part 854, at page 303, Buhari and Obasanjo, 2003, 17 NWLR, Part 850, at page 423. It is the conclusion in this judgment that running mate for a governorship election is not a necessary party in an election by virtue of Section 178 of the 1999 Constitution. He is an appendage to the candidate in the race for the governorship election and is bound by whatever decision the electorate or at the election tribunal decides. He rises and falls with the candidate. End of quotation. This position is true in the case of the Vice President, who was nominated by the presidential candidate to contest the presidential election. Similarly, this position was restated by Karibu White JSC in yet another case, Ayodele Oni, citation of which is cited. His Lordship has said, the situation in this appeal is different from the cases relied in the submission by Learning Council through the appellant, where a necessary party to an action for one reason or the other was not joined. The non-joiner will not render the judgment nullity. It is a correct proposition of the law that where an action is properly constituted, with the plaintiff with legal capacity to bring the action, a defendant with the legal capacity to defend, and a claim with cause of action against the defendant, and the action has satisfied all preconditions for instituting the action. The fact that a necessary party to the action has not been joined is not fatal to the action, and will not render the action a nullity. Where the nature of C. Oladeyinde and Oduole, 1962, Western Nigeria Law Report, 41. Where the nature of the evidence before the court is such that the case of the parties before it can be determined in the absence of those not joined, they can proceed to do so. It is only in those cases where it will not be right, and the court cannot properly determine the issue before it, in the absence of the parties whose participation in the proceeding is essential for the proper, effectual, and complete determination of the issue before it, would it be necessary to insist on the joinder of such necessary parties. End of quote. I also set out some other cases on the same position of the law. I also made reference to the ruling of this court delivered on the 22nd of August 2019 in the petition number CA/A/PEPC/29, 2009, Chief Ambrose Albert Owuru and the President Muhammad Buhari and two others in the applicant's motion number of 9th of May 2019, seeking the same relief. In the premises of the binding Nigerian authorities decided on their peculiar in the premises of these binding Nigerian decisions, the Kenyan foreign authority decided on the peculiar facts and the Constitution cited by the first respondent applicant are not opposite on the position of the law in Nigeria, and so they are not applicable. In the result, the prayer of the first respondent seeking to strike out this petition for non-joinder of the vice presidential candidate of the second and third respondent as a party to this petition is not well-grounded in law. It lacks merit. It is refused and hereby dismissed accordingly. My learned brother to my immediate right will pronounce his own decision in respect of this motion.
I agree with the ruling just delivered.
My learned brother to my immediate left would also say his decision in respect of this motion.
I also agree.
My learned brother to my extreme right will now say his own decision in respect of this motion.
I also agree.
My learned brother to my extreme left would also say his decision in respect of this motion.
I agree.
You have copies of it? You have copies? You have copies of it? You have copies? You have copies? You don't know? You don't know? You don't have? You have it. You don't have it. You don't have it. So there are these. Okay. The second one. You have it? You do have it? Okay, you have it?
That is one of the rulings on the pending applications before the tribunal. Let's once again welcome you to the live transmission of the judgment by the Presidential Election Petitions Tribunal in the petition filed by the PDP presidential candidate in the 2019 presidential election, Atiku Abubakar, against the re-election of President Muhammadu Buhari of the All Progressives Congress, the APC. There are a number of applications that the tribunal had reserved judgment to be taken along with its reserved ruling, that is to be taken along with the judgment that will be delivered on the application, and that is what is going on as we speak. A ruling in one of the applications, whether they not joining the vice presidential candidate of the APC, that is Vice President Yemi Osinbajo, would nullify. It's a ground on which the petition cannot be entertained. It was seeing the justices taking their positions on the ruling. Several instances have been cited in the lead ruling on that particular application that such will not necessarily invalidate the petition. So we'll wait to listen to what the position of the justices would be. Let's also remind you that the panel is actually made up of 5 justices. We have the chairman of the panel in the person of Justice Mohammed Garba, who took over from the president of the Court of Appeal, Justice Zainab Abukachua, who had to voluntarily step down at some point during the proceedings, hearing of this particular petition based on application brought by the PDP, even though the tribunal had ruled against the PDP in that particular petition, in that particular application, that she should rescue herself from the panel. The tribunal had ruled that by the virtue of the fact that she is married to a member of the PDP, senator, then senator-elect, now the senator, would not prevent her from sitting on the tribunal. But after the ruling, she voluntarily stepped down, that should not hinder the course of justice. That's when Justice Mohammed Garba, the presiding judge of the Court of Appeal from the Lagos Division, replaced as came in as the chairman of the tribunal. Other justices who are on this five-member panel, Justice Peter Olabisi Ige. We also have Justice Abdul Aboki, Justice Joseph Ike, and Justice Samuel Oseje. So in each of the rulings that will be possibly delivered on either of the applications that are pending, and then the applications that rulings must be taken along with the judgment. Each of the justices will state their positions on the matter and moving forward. So that's where we are. I'm sure the issue will be sorted out eventually, and each and every one of them would take their positions. It's going to be a long day, obviously, because it's not before the tribunal goes into delivering judgment on the petition itself. Like I observed earlier, there are a number of applications that would, be ruling must be delivered before the judgment itself. It's the judgment day, and also it will also be the possibly the final day of the tribunal, because remember there were 4 petitions before this particular tribunal that were all filed before the statutory period within which applications were allowed, petitions were allowed by law, arising from the February 23 presidential elections. There were actually 4 petitions that were filed before this tribunal. One of them was withdrawn by the petitioners, and then we had the tribunal, I think, deliver judgment in 2 of them. The petition of the Hope Democratic Party and its presidential candidate. Judgment was delivered in that. And then we also had the petition of the People's Democratic Movement, PDM, that judgment was also delivered. So 3 of the petitions done with. This is the last petition being considered by the Presidential Election Petitions Tribunal. And hopefully before close of day, though it will be a long day, before close of day today, judgment will be delivered in this, and the tribunal would round up its proceedings moving forward And whoever is not satisfied with the judgment that will be delivered today and even in previous petitions before this tribunal will have to proceed to the Supreme Court. So after this tribunal, all eyes will possibly be on the Supreme Court, just in case any of the parties who is not satisfied with the judgment decides to go to the appellant court for a review of such judgment moving forward. Let's also tell you the hearing of this particular petition of the PDP presidential candidate, former Vice President Atiku Abubakar, actually started sometime in May, precisely on started in May. Going by the provisions of the law, all the petitioners needed to file their petitions before March 20, which they all did, and hearing in the petition of the PDP presidential candidate Atiku Abubakar actually commenced on May 8th. So from May 8th till now, a lot have gone through. We've seen the first instance, the petitioner opened his case against the re-election of President Muhammadu Buhari, which was considered, and then we also saw other parties in this matter. The People's Democratic Party also making its position. We also saw the All Progressives Congress presidential candidate Atiku Abubakar also opening his defense to actually respond to the issues or the claims made by the petitioner. After that, we also saw the APC itself adopting the position, opened its defense, but eventually adopting the position of its presidential candidate. We also saw the Independent National Electoral Commission, which is also a party in this matter, also opening its defense, defending its conduct of the elections. It was a long one. Witnesses were called. A lot of evidences of exhibits were also presented as evidence before the panel. And then eventually we saw the parties adopt their written addresses. That was done. The final adoption of the written addresses was done on August 21, when the tribunal reserved judgment. And as at yesterday, they had communicated to the councils that judgment will be delivered today, and here we are. So, like we had informed you, the first ruling by the tribunal has gone through. It's actually striking out an application by the Independent National Electoral Commission, that is INEC, that was requesting the tribunal to strike out the petition of the PDP presidential candidate Atiku Abubakar for not joining the Vice President Yemi Osinbajo as a party to the matter. The court has ruled that the Vice Presidential candidate of the APC, as it were then, now Vice President Yemi Osinbajo, is merely, putting their words, merely an appendage or an interested party, but not a statutory party. Therefore, not joining the Vice Presidential candidate cannot render the petition incompetent. Which the implication of this is that the tribunal will go ahead to also deliver judgment in other applications that are before it, and then eventually take the judgment.
But the Nigerian Bar Association affixed to the petition the list of petitioners' documents and list of petitioners' witnesses to be relied upon in this petition. D, that he was conferred with the rank of Senior Advocate of Nigeria, SAN, in 1999 by the Legal Practitioners Privileges Committee. E, that by the instrument by which the rank of Senior Advocate of Nigeria was conferred on him, his name was written as Levi I. Uzoku. F, that his name is on the roll of the legal practitioners licensed to practice in Nigeria. G, that there is no other person who was called to the Nigerian bar in 1982 or at any other time that shares the name Livinus Ifeanyichukwu Uzoku with Dr. Levi Uzoku Ezean. H, that the name Dr. Levi Uzoku Ezean endorsed on the petition and other processes filed on behalf of the petitioners / respondent is the same as Levi I. Uzoku, which appears on the Certificate of Conferment of Senior Advocate of Nigeria, SAN, attached hereto as Exhibit AA, as well as Livinus Ifeanyichukwu Uzoku SAN, which appears on the Nigerian Bar Association stamp and seal, affixed to the list of documents to be relied on in this petition and the list of petitioners' witnesses. I, that Exhibit AA, which was signed by the Chief Justice of Nigeria, said that the name Levi I. Uzoku is the barrister and solicitor of the Supreme Court of Nigeria. J, that there is nothing wrong in the use of abbreviations in one's name or initials in signing documents, court processes, and or conducting proceedings in any court of law in Nigeria, as was done by him in respect of the list of documents to be relied in the petition and the list of petitioners' witnesses in this case. K, that being an officer of this honorable court, who has appeared in different cases for several years, the fact of his name being on the roll kept by the Chief Registrar of the Supreme Court is not and has never been in doubt. L, that he was Attorney General of Imo State from 1994 to 1996. M, that he has represented the first respondent / applicant in previous election petitions since 1999 without any objection whatsoever to his status as a legal practitioner by the first respondent or any other person whatsoever except in this petition. N, that he is duly licensed to practice law in Nigeria and was admitted to the bar, to the inner bar in 1999 on the same day with Yunus Ustaz Usman Ezean, the lead counsel to the first respondent / applicant. On the face of this averments by the respondent, first respondent, by the petitioners, the first respondents decided to blow a muted trumpet in respect of these fundamental facts in this petition. In the counter affidavit showing that the name Dr. Livy Uzoku Ezean is the same as Livy I. Uzoku, conferred with the rank of the Senior Advocate of Nigeria in 1999, along with the first respondent senior counsel, Ustaz Yunus Usman Ezean. The averments also show that Dr. Livy Uzoku Ezean was called to the bar in 1982, and he does not share the name Livinus Ifanichuku Uzoku or Dr. Livy Uzoku Ezean with any other person. The law is now tried that when facts are provable by affidavit, and if one of the parties deposed to certain facts, his adversary has the duty to swear to an affidavit to the contrary if he disputes such facts. Whereas in the instant case, such a party fails, neglects to swear to an affidavit to controvert the facts, such facts are to be regarded as duly established, and the party deemed to have considered and admitted as true and correct. I made reference to some cases on this principle. In the absence of any affidavit against the fact deposed to in paragraph 5 and 6 of the petitioner's counter affidavit, the first respondent would appear to have thrown in the towel and backed down on the allegation that Dr. Livy Uzoku Ezean's name is not on the roll of legal practitioner called to the Nigerian bar. It is therefore not surprising that nothing was said on the issue in the first respondent reply on points of law, which was filed on the 5th of May, 2019, concerning this unfounded allegation that Dr. Livy Uzoku Ezean is not a legal practitioner called to the Nigerian bar. In this premise, I am of the view that the petitioner's list of documents to be relied on in this petition and the list of petitioner's witnesses, which were all filed along with the petition hearing on March 18, 2019, appearing at pages 141 to 145 and 146 to 157 of the petition, were all validly, competently and signed by a legal practitioner whose name is on the roll kept by the Chief Registrar of the Supreme Court, and that is Dr. Livy Uzoku Ezean. The next prayer sought on the first respondent application is for an order to strike out ground D and E of the petition because they are said to be incompetent in that they are said to be on pre-election matters. The learned senior counsel had argued that the ground D and E, the learned senior counsel for the petitioners / respondent had argued that because ground D and E affect the second respondent directly, it will not be the business of the first respondent / applicant, an independent body, which should be impartial to hold brief for the second respondent in respect of the said grounds. However, because the challenge by the petitioners, by the first respondent to grounds D and E is a challenge to the jurisdiction of this court to entertain the said ground, it is open to any of the respondents to the petition to raise the said issue. The settled position of the law is that consent or acquiescence or failure to raise a jurisdictional point in action will not confer jurisdiction on the court where it has no jurisdiction to entertain any cause or issue. The contention of the applicant in this application is that this court cannot adjudicate on the identified grounds because they are caught by time bar or limitation contained in section 285(9) of the Constitution of the Federal Republic of Nigeria as amended, which provided that every pre-election matter must be filed within 14 days of accrual of the cause of action. The court can, on its own motion, even without any party raising it, raise an issue which directly affects its virus or jurisdiction to adjudicate on any of the issues or grounds contained in this petition. I then refer to the case of Ndul and Wayo, where the Supreme Court, Pakekere Ekun, described the issue of jurisdiction as follows. Jurisdiction is the authority or power of the court to adjudicate over a cause of matter brought before it for resolution and ought to take cognizance of matters represented in a formal way for its decision. A court of law, being a creation of the Constitution or of a statute, can only exercise the jurisdiction conferred on it by law that created it. See National Bank and another against Shoyoyi, 1977, 5 SC reprint, 110, Mobile Production Nigeria Unlimited, and La Cepa, and others, 2002, 14 SCM, 167, at 179, 2002, 18 NWLR 7981, Obasanjo and Yusuf, 2004, 9 NWLR, Part 877144, Achonu and Okobi, 2017, 14 NWLR, Part 1584, page 142 at page 171. Jurisdiction is so fundamental that any proceeding conducted without it is a nullity and liable to be set aside, no matter how well conducted. See Modukolu and Nkendilim, 1962, 2 SCNLR 341, 1962, 2 All Nigeria Law Report, 587 at 594, Scant Council Nigeria Limited and UK, 1981, 1 SC6 at 52, Inakoju and Adeleke, 2007, 4 NWLR, Part 20, 1025, at page 427, at page 588. It is because of the futility of proceedings conducted without jurisdiction that an issue may be raised at any stage of the proceedings in any manner, even for the first time on appeal, before the apex court. End of quote. I also made reference to some other cases dealing with jurisdiction. Now, the grounds set out in paragraph D, 15D and E of the petitioner's petition are as follows, and I quote them. Paragraph D. The second respondent was at the time of the election not qualified to contest the said election. And paragraph E, the second respondent submitted to the first respondent an affidavit containing false information of a fundamental nature in aid of his qualification for the election. End of quote. The facts pleaded in support of the above grounds of the petition can be found in paragraph 388 to 405 of the petition, and I set them out. The law is now beyond argument that ground D of the petition as set out above on the qualification of the second respondent to contest the election in question is both a pre- and a post-election question or issue, which could be competently taken before the courts mentioned in section 31(5) of the Electoral Act as amended, or the election tribunal or court as, and this court as a trial court in the presidential election. In the case of PDP and INEC, Supra, cited by the petitioners, Okoro JSC tacitly stated the position when he said, and I quote him, "As I mentioned earlier, a person who wishes to challenge the election on the basis that the winner was not qualified to contest the election has umbrage under section 138(1)A of the Electoral Act. That is to say, where a person failed to take advantage of section 31, sub 5 and 6 of the Electoral Act Supra in the High Court, you can still approach the election tribunal under section 138(1)A thereof." In the later case of Dixon and Silva, a case decided in 2017, and citation of which is set out, Sanusi JSC succinctly put the position thus, and I quote him, "As can be seen from the wordings of section 138(1)A of the Electoral Act 2010 as amended, the issue of qualification of a candidate to contest an election can be a ground in an election petition to question the election of the declared winner. Such a ground could be fought both at the tribunal as well as the normal or conventional high courts, as both the tribunal and the High Court have jurisdiction, end of quote. These two decisions of the Apex Court, among a litany of others, are sufficient for me to hold and say, without any further ado, that ground D of the petition is a competent and valid ground under the law to vest the requisite jurisdiction on this court to adjudicate over it. Next is ground E in paragraph 15E. Prior to the amendment of the Electoral Act by the Act number 15 of 2015, which came into effect or operation on the 26th of March 2015, there were only 4 grounds provided for under the hitherto section 138(1) on which an election could be questioned in an election petition. The 4 grounds numbered A to D have been retained in the amended Act under the same section 138(1), which, however, has brought the additional ground numbered as E. The new and additional ground on which an election may be questioned in an election petition introduced and provided for under the said 138(1)(e) of the amended Electoral Act is in the following terms, and I quote, E, that the person whose election is questioned has submitted to the Commission affidavit containing false information of a fundamental nature in aid of his qualification for the election, end of quote. It cannot reasonably be argued that the provisions of section 138(1)(e) above are not quite clear, unambiguous, and simple in their words and tenor, and so the only legitimate duty of this court is to assign and ascribe ordinary and literal meaning to them in the determination of the intention of the legislature in enacting them. Okoro JSC, the very recent case of Nweke and FRN, decided this year, 2019, and citation of which is set out, restated this position when he said, and I quote, I must state that the law is well established in the interpretation of a statute, and it is that it should always be given its ordinary meaning. Where the words of a statute are clear and unambiguous, any addition or subtraction will tantamount to introducing illegal backdoor legislation or amendment. See Skybank PLC against Victor Anamen, EU, 2017 LPELR 42595 SC, 2017-18 NWLR, Part 1590-24, Elabanjo and Daudu, 2006, 15 Nigeria Wiki Law Report, Part 1001 at page 76, end of quote. See also Obasanjo Yusuf and other cases which I have set out. The provisions of section 138(1)(e) above, put simply and ordinarily, provide that an election conducted under the Electoral Act may be questioned on the ground that the person whose election is questioned has submitted to INEC, the Commission, an affidavit containing false information of a fundamental nature which aided his qualification for the election. Expressly and unequivocally, the purport of the provisions and the legislature is to make the submission of an affidavit containing a false information of a fundamental nature in aid of his qualification by a person whose election is questioned, a ground for challenging or questioning the said election of the person. Undoubtedly, the submission of an affidavit to INEC required under section 31(2) of the Electoral Act is an event or act or activity that preceded an election that may be questioned by the ground provided for in the provision, which, however, is intricately and inextricably linked, connected, and tied to the qualification of the person whose election is questioned to contest the election. The legislature, aware of this position, and in its wisdom, has deliberately and expressly made the submission of an affidavit containing false information of a fundamental nature in aid of his qualification a ground on which an election may be questioned, thereby making it a question or issue which can competently and validly be taken before the election tribunal in an election petition. I refer to the case of Okadibo and Obiano, decided in 2015. It has been argued by the learned senior counsel for the first respondent applicant that the ground deals with pre-election matter as defined under Section 285, sub 14 of the 1999 Constitution as amended. The provisions of the said section are as follows, and I quote, Section 285.14. For the purpose of this section, pre-election matters mean any suit by A, an aspirant who complains that any of the provisions of the Electoral Act or any act of the National Assembly regulating the conduct of primaries of political parties and the provisions of the guidelines of a political party for the conduct of party primaries have not been complied with by a political party in respect of the selection or nomination of candidates for an election. Then B, an aspirant challenging the action, decisions, or activities of Independent National Electoral Commission in respect of its participation in an election, or who complains that the provisions of the Electoral Act or any act of the National Assembly regulating election in Nigeria has not been complied with by the Independent National Electoral Commission in respect of the selection or nomination of candidates and participation in an election. And C, a political party challenging the actions, decisions, or activities of Independent National Electoral Commission disqualifying its candidate from participating in an election, or a complaint that the provisions of the Electoral Act or any other applicable law has not been complied with by the Independent National Electoral Commission in respect of the nomination of candidates of political parties for an election, timetable for an election, registration of voters, and other activities of the Commission in respect of preparation for an election, end of quote. As can easily be discerned, paragraphs A and B of this provision talk about an aspirant, in quote, who complains that the provisions of the Electoral Act or any other act of the National Assembly regulating the conduct of party primaries or party guidelines have not been complied with in the selection or nomination of candidates, or who challenges the actions or decisions or activities of INEC in respect of his participation in the election, or that the Electoral Act or any other act were not complied with by INEC in the selection or nomination of candidates and his participation in an election, respectively. Section 156 of the Electoral Act as amended, defines the word aspirant in Section 156 as follows. Aspirant means a person who aspires or seeks or strives to contest an election to a political office, end of quote. Rose Bible, JSC, in the case of PDP and Silva, consolidated, citation of which is set out, define the word aspirant thus. An aspirant is a person who has a strong desire to achieve a position of importance or to win a competition. An aspirant is a person who contested the primaries, end of quote. See also Adlo and Nyako, citation of which is provided. The provisions of paragraph A and B above clearly you would complain by an aspirant in respect of the conduct of political party primaries for selection or nomination of candidates. The provisions, therefore, have no bearing, no relationship whatsoever with the ground on which an election may be questioned by a candidate or a political party who participated in an election as provided for under Section 138(1)(e) of the Electoral Act. Paragraph C, on its part, deals with the complaint or challenge by a political party to actions, decisions, or activities of INEC in disqualifying its candidate from participating in an election, or that the provisions of the Electoral Act or other acts were not complied with by INEC in respect of the nomination of candidates, timetable for election, registration of voters, or other activities in preparation for an election. This paragraph simply provides for a challenge by a political party to INEC's action, activities, and decisions on disqualification of its candidate, on timetable for an election, registration of voters, etc., in preparation for an election. Like paragraphs A and B, this paragraph, in my firm view, has nothing to do with the ground on which an election may be questioned as provided for in Section 138(1)(e) of the Electoral Act. In the result, I am of the view that the ground provided for in Section 138(1)(e) of the Electoral Act as amended, on which an election may be questioned in an election, does not come or fall within the purview or even contemplation of the definition of a pre-election matter under Section 285(14) of the 1999 Constitution as amended. The ground does not fall under pre-election matters defined in Section 285(14) so as to be affected by the limitation of time prescribed by the provisions of Section 285(9) of the Constitution, within which such matters are to be taken, brought, or filed in court. Although the ground would appear to deal with an event or activity that happened before the conduct of an election, like the issue or question of a candidate's qualification to contest an election, which is both pre- and post-election for the purpose of an election, the ground provided for in Section 138(1)(e) of the Electoral Act as amended involves an issue or question that can competently be ventilated before the regular courts under Section 31(5) and the election and/or the election tribunal or court in an election petition. In consequence whereof, I find no merit in the arguments of the applicant, the first respondent, on prayer 4 of the motion, and it fails and is refused. In respect of prayer 5 of the motion, it are contended that some of the paragraphs of the petition alleging improper accreditation, non-authentication of results, overvoting, inflation and deflation of votes, and wrong entries in Form EC8A ought to be struck out for their being imprecise, nebulous, and vague, having failed to identify the polling units where the alleged infractions took place. The paragraphs involved in this prayer are set out. The first respondent also praised that paragraph E, F, and G of the same paragraph the petition failed to give particulars of non-compliance or corrupt practices. It also contains that the person alleged to have committed various offenses were not joined, and I listed some of the paragraphs, all the paragraphs. I have calmly and critically examined the impugned paragraphs of the petition as listed out in prayers 5 and 6 of the motion paper, and I am of the view that paragraph 148, 149, 150, 151, 152, 153, 154, 155, 156, 157, 159, 160, 161, 162, 163, 190, 195, 198, 199, 200, 260, and 261 are not vague or nebulous. I am of the opinion that since the first respondent has joined issues with the petitioners in the reply to the petition, the first respondent cannot, in fairness, contend that the paragraphs of the petition quoted are vague, nebulous, or imprecise. Otherwise, he wouldn't have joined issues in respect of the same paragraph. Having understood this paragraph well and reacted to them, it cannot be hard to now say that the paragraphs are nebulous, imprecise, and vague. The next prayer to consider are reliefs, the ones in relief 7 and 8 of the motion paper. And they will be taken together because they have to do with the non-joinder of persons or organizations accused of intimidation, harassment of voters and supporters of the petitioners in the election. Some of the persons named in the paragraphs of the petition listed under prayer 7 and 8 were accused of violent acts and bordering on criminality. The main contention of the first respondent here is that this court cannot determine the allegation in the absence of such persons accused of crimes, as that would amount to a breach of their rights and obligation protected under Section 36 of the Constitution of Nigeria. And in argument, rebuttal, Learned senior counsel for the petitioner said that the Army personnel involved in this case were all agents of the first and second respondent. However, no one can run away from the settled position of the law in election dispute that a petitioner who disparages the conduct or character of any person by accusing such persons or individual of crimes or criminal offenses punishable with a fine or imprisonment ought to know that it is mandatory and statutorily required and important to join such person or individual so that they can defend themselves before the court against such allegations. The court would lack the varus or competence to entertain and adjudicate on any accusation, no matter how minute, leveled against any person in a petition where the nature of allegation is criminal. The court would be devoid of jurisdiction to pronounce against or decree against any person who is not before it and who has been accused of the commission of a crime of a criminal conduct. The cases on this principle of law are legion, so I just made reference to a few of them, starting with Egolem and Obasanjo, citation of which is set out, APC and PDP, decided in 2015, also citation set out, where Fabi in particular said that it is basic that there's no vicarious liability in the realm of criminal law. Anyone who contravenes the law should carry his own cross. The fourth and fifth respondent cannot therefore be found answerable to alleged crimes committed by their unknown soldiers or policemen in an election petition, end of quote. The impugned paragraphs listed under Prayer 7 of the petition, the impugned paragraphs of the petition under Prayer 7 of the petition are paragraphs 227, 231, 232, 233, 234, 236, 250, 293, 299, 302, 302, 306, 308, 309, 310, 317, 322, 328, 329, 333, 335, 373, 380, and 381, while the paragraphs impugned or complained of in Prayer 8 on the motion paper are paragraphs 277, 334, 336, 338, 349, 350, 368, 369, 370, 371, 372, and 383. The said paragraphs, after a calm examination, I am of the view that the said paragraphs are all liable to be struck out as they contain serious allegations of crimes and undue interference with the electoral processes against the persons named therein who are not parties in this petition. I have also read paragraphs 277, 213, 226, 236, 326, 334, 336, 349, 350, 352, 385E and F, 368, 369, 370, 371, 372, and 383 of the petition under Prayer 8. And I'm equally certain in my mind that they raise and involve serious allegations of crimes, corrupt practices, violence, unlawful interference with electoral processes which have been made against individuals and persons who have not been made parties to this petition. The court cannot make any pronouncement of indictment against the said person or individual without infringing on their fundamental right to fair hearing, as enshrined in Section 36(1) of the Constitution of the Federal Republic of Nigeria, which I set out. Allegations made against persons indicted in these petitions cannot be fairly and impartially be dealt with in the absence of those identified in the paragraphs. Consequently, the said paragraphs are liable to be and are hereby struck out accordingly. In the final result, this application partially succeeds only in terms of prayers 7 and 8 of the motion paper. The paragraphs named therein are hereby struck out once again. The application fails and is refused in respect of prayers 2, 3, 4, 5, and 6 of the motion paper, which are hereby dismissed. The court shall now proceed to deal with the balance of the paragraphs. My learned brother to my immediate right will pronounce his decision in respect of this motion.
I agree with the ruling just delivered.
My learned brother to my immediate left will also read his own decision in respect of this motion.
I also agree.
Abba. Put them in this already. My learned brother, excuse me. My learned brother to my extreme right.
I also agree.
All right. My learned brother to my extreme left will also pronounce his decision in respect of this man.
I agree.
Now go to the next motion by the second respondent. Now go to the next motion. The next motion by the third respondent. The first respondent. That's 3.
Okay, first respondent.
Lastly, for the first respondent, there's this other motion, which he filed on the 24th of April, 2019. And this is the leading ruling in respect of the said application. Okay. The application seeks for, 1, an order striking out part 1 of the petitioner's reply to the first respondent's reply to the petition, dated 15th of April 2019, for being in violation of section of the Electoral Act 2010 as amended. And then 2, an order striking out paragraphs 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 to 24 of part 2 of the petitioner's reply to the first respondent's reply to the petition, dated and filed 15th April 2019, for being in violation of the provisions of the Electoral Act 2010 as amended. And the grounds upon which the prayers are premised are set out. A loan issue, the motion was supported by an affidavit of 7 paragraphs and a written address. Of course, the petitioners filed a counter affidavit of 6 paragraphs, along which is attached a written address. The first respondent also filed a reply on point of law. A loan issue was raised for determination in this application, and it is the contested averments in the petitioner reply in conformity with the express provision of paragraph 16.1 and paragraph 16.1a of the schedule to the Electoral Act 2010 as amended. I went on to consider the submissions of the senior counsel for the parties. On the sole issue. Now, after a consideration of the submissions by the learned senior counsel for the parties, on particularly the provisions of paragraph 16.1 of the first schedule to the Act, I went on to decide as follows: that the apex court in the land had in numerous cases treated the scope, the meaning, the function, and the real import of the reply as part of pleadings in civil proceedings and in election matters which are sui generis. While filing a reply in civil proceeding is governed by the applicable rules of court, cease of the cause of matter, filing of a reply in election petition proceedings is regulated by statute, relating to the said election petition. And I made reference to OJ and Babalola, decided in 1991. And also the case of Oshodi and Eifumi, among other cases. And I said the Supreme Court had cause to consider paragraph 16.1 of the first schedule to the Electoral Act as amended in the case of APC and PDP, decided in 2015, citation of which is set out, where Fabi JSC said, the last notable issue is whether the Court of Appeal was not correct in its decision affirming the tribunal's striking out of paragraph 13 of the petitioner's reply to the second respondent's reply to the petition, when the said paragraph was in fact filed in contravention of the applicable provisions on reply and pleadings. Let me start by observing that paragraph 16.1a of the first schedule to the Electoral Act regulates the content of the reply that may be filed by a petitioner in answer to the reply of a respondent to the petition. It provides as follows. 16.1. If a person in his reply to the election petition raised new issues of facts in defense of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from receipt of the respondent's reply, a petitioner's reply in answer to the new issues of fact. So, however, that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him. I think that I should repeat it, that proceedings and election petitions are sui generis. They are in a class of their own. They are made to fast-track the hearing of petitions. They are, however, not designed to spring surprise on the party, end of quote. More recently, in the case of Silva and INEC, His Lordship, IT Muhammad JSC, now CJN, firmly held, and I quote him, Your Lordships, the circumstances under which a petitioner may file a reply to the reply filed by a respondent to the petition are clearly provided by the first schedule to the Electoral Act 2010 as amended. It provides as follows, 16.1. If a person in his reply to the petition raises new issues of facts in defense of his case which the petitioner has not dealt with, the petitioner shall be entitled to file a reply in the registry within 5 days from the receipt of the respondent's reply, a petitioner reply to the new issues of fact, so however that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds or prayers tending to amend or add to the contents of the petition filed by him, and B, the petitioner reply does not run counter to the provisions of subparagraph 1 of this paragraph, or paragraph 4 of this schedule. It is clear from the above quoted provisions of the Act that one can easily conclude that a petitioner may only file a reply to the reply of a respondent where any issues of fact are raised by the respondent. Where a respondent raises no issue of fact in his reply, but simply answers the fact in the petition, the petitioner does not have a right of reply to the same, end of quote. In order to determine whether the reply of the petitioners to the first respondent's reply to the petition is competent or in breach of paragraph 16.1 above, there is the need for a reproduction of the preliminary objection by the petitioners, by the petitioner to the reply, preliminary objection by the first respondent to the reply filed by the petitioners. And we went on to set them out. Now, part 1 of the petitioner reply deals with the above the objection with the first respondent tag, A on pages 1 to 4 of the first respondent reply to the petition. On ground A as to whether they complied with paragraph 4.1c of the first schedule to the Electoral Act 2010 as mandatory requirements of stating scores of the party as announced by the first respondent, and the issue whether the result was pleaded is a matter of perusal of the petition and the evidence at the trial. The petitioner's reply in paragraph 1 is therefore unnecessary. With regard to paragraph 2 of the petitioner's reply, dealing with whether there is contradiction in the relief sought, I am of the view that it is a point of law and depends on the examination of the petition itself. Paragraph 2 is therefore unnecessary. Paragraph 3, 4, 5, 6, and 7 of the petitioner's reply to the first respondent's reply to the petition are in order because, 1, the first respondents raised the issue as to whether the Lions Senior Counsel to the petitioners was called to the Nigerian bar. 2, the first respondent asked the court to strike out the petition and the accompanied list of witnesses and list of documents. 3, the first respondent raised the issue as to whether reliefs D and E, which also constitutes some grounds in the petition as falling under Section 285, 14b of the Constitution of the Federal Republic of Nigeria as amended. The first respondent, therefore, thereby raised new issues of facts in the defense which were not dealt with in the petition. However, paragraphs 8, 9, 10, 11, 12, and 14 of Part 1 of the petitioner reply to the first respondent reply to the petition are contrary to the intendment of paragraph 16(1)(a) and 2 of the first schedule to the Act. The reasons are not far-fetched and are as follows. 1, paragraph 8 and 9 are efforts at embellishing the paragraphs of the petition already pleaded and explain reasons behind the pleading. Paragraph 10 introduced facts that ought to have been pleaded in accordance with paragraph 4 of the first schedule to the Act. Paragraph 11 introduced principal and agency relationship into their petition in breach of paragraph 14(1) of the first schedule to the Act as amended. And 4, the question as to whether the first respondent is bipartisan or is rallying around the second respondent were already part of the pleading of the petitioner, and same cannot be reintroduced in reply to the first respondent's reply to the petition. The facts contained in paragraph 15 of the reply to the first respondent reply to the petition are for the court to decide. In the result, paragraphs 1, paragraph 2, paragraph 8, paragraph 9, 10, 11, 14, and 15 of Part 1 of the petitioner reply contravene paragraph 16 of the first schedule to the Electoral Act and are liable to be struck out. They are hereby struck out. Part 2 of the petitioner reply to the first respondent reply to the petition has to do with the facts pleaded in paragraph 3, so many paragraph 3 which are set out. All the facts pleaded by the first respondent in their paragraph 3, 4, and 5 of their reply to the petition are responses to the facts pleaded in paragraph 2, paragraph 3, 4, 5, 6, 7, and 8 and 9 of the petitioner's petition, and no new issues of facts were raised by the first respondent in the said paragraphs to warrant any reply from the petitioners as contained in the said paragraphs. There are new facts and an attempt to add new facts, which is an amendment to the contents of the petition and which are not allowed under paragraph 16(1) of the first schedule. They ought to be, and they are hereby struck out. The first respondent pleaded in paragraph 10 and 11 of his reply to the petition that it denies paragraph 18, 19, 20, and 21 of the petition, and denied that contrary to the assertion of the petitioner to the effect that the first respondent wrongly and lawfully credited the second respondent with invalid votes, and a denial of the table of alleged scores of candidates constructed under paragraph 21, which the petitioners claim to have gotten from the first respondent server. In breach of paragraph 16 of the first schedule to the Electoral Act as amended, the petitioners took on undue umbrage to plead facts in paragraph 5 complaining about wrong crediting of votes to some candidates in the presidential election. The petitioners also pleaded new and additional facts on transmission of results online via the website tagged www.inecnigeria.org. They pleaded further that they visited the website on the 12th of April 2019 at 4:58 p.m. All through paragraph 7, 8, 9, 10, and 11, the petitioner clearly pleaded new facts relating to INEC server, electronic voting, information, data, document, footages, images, and paragraphs, and that the result, photographs, and that the result relied upon by the petitioners are products of electronic transmission of votes cast for the candidates are transmitted electronically by the first respondent's official. Paragraphs 10 and 16 of Part 2 of the petitioner's reply to the first respondents are also new facts about what the petitioner described as, and I quote, first respondent presidential results sheet server 1, end of quote. The petitioners also pleaded in paragraph 10 that the second petitioner was reported to DSS and Inspector General of Police on allegation that they hacked into INEC server, and also stated that Mr. Festus Kiyamo Ezien accused the first petitioner of having smuggled the data into the server. Paragraph 11 stated that the petitioners will rely on experts on Microsoft, IBM, and Oracle, among others of the trial. Now, in paragraph 15, 16, and 19 of the first respondent petition, and in answer to paragraph 26, 27, 28, and 29 of the petition, wherein the petitioner pleaded that smart card readers were deployed by INEC in addition to accreditation to transmit results, votes electronically, and that they will rely on the first respondent manual for respondent manual of technology 2019, which the first respondent denied. The petitioners in paragraph 12 to 16 of Part 2 of their reply to the first respondent now pleaded additional facts and fresh issues relating to the use of smart card reader, meetings of INEC officials with stakeholders, and press release by one Festus Okoye, Chairman, Information and Voter Education Committee of INEC. The petitioners also pleaded that the Electoral Act did not allow the transmission of election results by electronic means. Paragraphs 8 to 16 of the said Part 2 of the petitioner reply are also caught in the web of paragraph 16(1)(a) and (b) of the first schedule to the Electoral Act. Paragraph 16, 19, paragraph 17, 18, 19, 20, 21, 22, 23, 24, 25, and 26 of the petitioner reply to the first respondent also pleaded new facts in addition to the Constitution herein reference, and to the answers and denials of the first respondent with particular reference to the elections in states which are set out. The first respondent did not raise any issue of facts to engender a reply from the petitioner to file a reply to the first respondent's reply. The petitioners also in paragraphs 107, 108, 109, 110, and 111 of the petition under Grant 2, dealing with non-compliance with the provisions of the Electoral Act 2010, complaint of non-holding of election, cancellation of election results, and stating that because the first respondent admitted the breaches stated, the first respondent ordered supplementary election in 14 states of the Federation, stating the number of polling units affected in paragraph 108, and pleading the results which the petitioners believe were cancelled and that there was voting, that there was overvoting. These complaints pleaded by the petitioners in paragraphs 107, 108, 109, 110, and 111 of the petition are what the first respondent addressed and replied in paragraphs 62(1) to 9 of the first respondent's reply. All that the first respondent said in the said paragraph 62 is that the assertion of the petitioners are misleading and untrue without raising any new issues or facts in the first respondent's defense. The denials contained in the said paragraph 62 of the first respondent reply to the petition cannot attract any reply from the petitioners. The same is also true of paragraph 63, sub 2c of the first respondent's reply. Paragraphs 22 to 26 of the petitioner's reply in part 2 to the first respondent's reply are not permitted and contravene paragraph 16, 1A and B of the first schedule to the Electoral Act, as there's nothing new or which raises fresh issues of fact in the first respondent's reply in paragraph 64 and 76F in the first respondent's reply to warrant the pleadings in the said paragraphs. The result is that part 2 of the petitioner's reply to the first respondent reply to the petition, particularly paragraphs 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 22, 23, 24, 25, and 26 of the reply are liable to be struck out and are hereby struck out for being in flagrant breach of paragraph 16A and B of the first schedule to the Act. In the final result, this motion succeeds as stated above, partially and fails partially. My learned brother to my immediate right will now say his decision in respect of this motion.
I agree.
My learned brother to my immediate left will also say his decision in respect of this motion.
I also agree.
My learned brother to my extreme right will say his decision in respect of the motion.
I agree.
My learned brother to my extreme left will also pronounce his decision in respect of this motion.
I agree.
No? It's the correspondent.
One was duplicated. This one was duplicated.
You start with the red file. You have this? No. You go back. I think that's Chinebo. Now we start with the one file on the 14th. Oh, this is the second. Okay, this is the second motion. This is the second motion.
Yeah, the first one.
Yeah, quick first one.
First one.
Which one is that? This one. This is the first one.
Yes.
This is the first one. The one filed on the 14th.
Yes.
14th of May. Order pray.
14th of May. No, this one.
This is the first one. Okay, the small one. This is the first one. Gentlemen, now go to the second respondent's motions. The second respondent has two applications, which you've taken. The first one, all of them were filed on the 14th of May, 2015. I'll begin with the lead ruling in the motion filed on the 14th of May, 2019, by the second respondent, which praised the court for the following reliefs. 1. An order striking out the entire reply by the petitioners filed on the 26th of April together with the witness statement on oath accompanying the reply, list of witnesses to be relied on, and the list of additional documents. Further, or in the alternative to prayer 1 above. 2. An order striking out paragraphs 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 16 to 20, 21 of part 3 of the petitioner's reply filed on the 26th of April 2019 to the applicant's reply to the petition. And 3, for such further order or orders as this Honorable Court may deem fit to make.
We have dealt with these issues. These are the issues that we dealt with.
Paragraph affidavit, as well as and in the written address by the Learning Senior Counsel for the second respondent, the issue submitted for determination in the application is as follows. Having regard to the alien and overreaching nature of the petitioner's reply filed on the 26th April 2019, purporting to reply to the applicant's reply dated 16th of April 2019, whether this Honorable Tribunal will not grant the applicant's application as prayed, end of quote. For Dr. Livy Uzoku, SAN, he also submits a single issue, which is, and I quote, whether this Honorable Court should, in the circumstances of this case, strike out the petitioner reply to the second respondent's reply to the petition duly filed in accordance with due process of law. After a consideration of all the arguments in respect of the issue, I noted that the issues in this application are similar to the ones which we have decided in the first respondent's application, particularly on the competence of the reply filed by the petitioners, particularly having regards to the counsel, whether he's on the role of legal practitioners. We also dealt with an objection raised by the Learned Senior Counsel for the petitioners, particularly to the application itself. And And after a consideration of all the arguments, I went on to decide the application. And I started by saying the main grounds of the petitioners on the issue of non-compliance with paragraph, that's the preliminary objection raised by the petitioners. That the main grounds of the petitioners on the issue of non-compliance with paragraph 12.3 of the first schedule to the Act is that copies of the said listed documents were not attached therein before, and therefore the petitioners with the second respondent's reply is incompetent. With due respect to the learned senior counsel for the petitioners, the position taken by the petitioners is not correct. See the case of INEC and Iniama, where Owade JSC said, the only punishment for disobedience being the inability of the petitioner to rely on documents not attached or listed as required. I'll take that again. The only punishment for disobedience being inability of the petitioner to rely on the document not attached or listed. I also cited the case of Igbeki and Imodi, also a decision of this court. Then, and I want to say that the fact remains that the petitioner under paragraph 4.5c of the first schedule to the Act, as amended, is given an opportunity to accompany his petition with copies of lists of every document to be relied on at the hearing of the petition. Though paragraph 12.3 states that a reply shall be accompanied by copies of documentary evidence, I am of the view that the reply of the second respondent complies substantially with the provisions of section 12.3 of the first schedule to the Act. I also exercise discretion under paragraph 53.1 of the first schedule to the Act not to void the second respondent's reply to the petition. In any event, as held by this court and the Supreme Court, that the only penalty, if any, to be suffered is that the party will not be affected, will not be allowed to use or rely on a document which he has not accompanied with his petition. And I refer to the case of AC and Lamido. In this case, the second respondent listed the document he intended to rely upon. The second respondent's amended reply to the petition is therefore competent. The second ground seeking for striking out the second respondent's amended reply is that paragraph 5.6 and 3A3 of the reply to the petition do not constitute a reply to the petition, and that the second respondent is not permitted to raise issue bordering on qualification or otherwise of the first petitioner when the second respondent has no counter affidavit in form of a petition against the first petitioner. What paragraph 6 of the second respondent's reply pleaded is that the petitioner could not have been returned because in the past the first petitioner had been in the third respondent with the second respondent, and in the past campaigned for the second respondent as the best choice for the position of the President of the Federal Republic of Nigeria before he left the third respondent. While in paragraph 3A3 of the second respondent alleged that the first petitioner was not qualified to contest the presidential election and challenged him to produce his educational credentials. Now, paragraph 12.1 of the first schedule to the Electoral Act, as amended, states thus: the respondent shall, within 14 days of service of the petition on him, file in the registry of this court his reply, specifying in which of the facts alleged in the election petition he admits and which he denies, setting out facts on which he relies in opposition to the election petition. Now, the piece of the averment in paragraph 3A3 of the second respondent amended reply to the petition is that the first petitioner was not qualified and so had no right to have contested the election in question. The paragraph seeks to challenge or question the competence or local standard of the first petitioner to present the election petition, which goes to affect the jurisdiction of the court to adjudicate over it by necessary implication. However, the second respondent has not denied the fact stated in paragraph 1 of the petition that the petitioner was the candidate at the election of the office of the President of the Federal Republic of Nigeria, which presidential election held on Saturday, the 23rd of February, 2019, across Nigeria. Section 137(1) of the Electoral Act, as amended, with the preamble, persons entitled to present election petition, provides thus, and I quote, an election petition may be presented by one or more of the following persons. A candidate in an election. B, a political party which participated in the election, end of quote. Undeniably, being a candidate who contested the election in question, the first petitioner was a candidate in the election who apparently had the statutory right, the local standi, and the legal competence to present the present petition, thereby vesting the court with the requisite jurisdiction and competence to adjudicate over the petition. In any case, since the competence of the first petitioner was questioned and challenged on ground of qualification to contest the election, the facts are incompetent in that the only ground cognizable under qualification to contest an election conducted under the Electoral Act is the one provided for in Section 138(1)(a), and it is that, I quote, that the person whose election is questioned was at the time of the election not qualified to contest the election. The first petitioner, is not the person whose election is questioned in this petition, and so the issue of his qualification to contest the election is non sequitur, diversionary, incompetent, and academic for this petition. In addition, in the case of Idris and ANPP, decided in 2008, Sanusi JCA, now JSC, has stated that, and I quote, here, the appellants question the propriety of the tribunal finding and conclusion that the disqualification of the second respondent could not be raised at the trial as a defense, having regard to the entire circumstances of the case, except by filing a cross petition. I do not think it is worthwhile to dissipate so much energy in resolving this issue. To my mind, the issue of qualification of a candidate is a ground upon which a petition can be presented. In fact, it is a distinct ground under the Electoral Act 2006, under Section 145(1)(a). It goes without saying, therefore, that if the appellant wanted to use the grounds of qualification of the second petitioner for whatever reason, it had to file a cross petition and not to use the alleged non-qualification against the second petitioner as a defense, end of quote. In the above premises, I find merit in the objection by the petitioners on the second respondent's paragraph 383 of the amended reply to the petition. The fact in paragraph 6 of the second respondent amended reply to the petition are also of no moment, as they are in respect of the political party primaries conducted in 2014 for the purpose of the 2015 general election. Paragraphs 6 and 383 of the second respondent's amended reply to the petition are, in the above premises, liable to be and are hereby struck out. On whether the second respondent's learned senior counsel, on whether the failure of the second respondent learned senior counsel to indicate his national identification number against his signature on the second respondent reply to the petition renders the reply incompetent or vitiated it, bearing in mind the provisions of paragraph 1U of Regulation 2017 made pursuant to the National Identity Management Commission Act 2007, I wish to rely on the definite finding of the Apex Court in the case of Senator APC and another against Senator Kabir Marafa, delivered on the 24th of May 2019, where Galimje said, and I quote, Section 27 of the National Identity Management Commission Act 2007 and its regulation are not part of the rules of this court and cannot, therefore, apply to the processes filed in this court. Clearly, I find no merit in the preliminary objection. Accordingly, same is hereby overruled. End of quote. The issue of national identification number was considered by this court when a similar objection was raised by the petitioner to an application by the second respondent to amend his reply to include address for service, and indicate the national identity number of the senior counsel for the second respondent. And this court found that the regulation has no application to this court in filing of process. See the ruling of this court in the motion filed on the 24th, in the ruling delivered in this petition on the 24th of June 2019. It must be further stated that Section 239 of the Constitution of the Federal Republic of Nigeria, as amended, specifically confers exclusive original jurisdiction to this court to hear and determine any action or petition as to whether any person has been validly elected to the office of the President or Vice President under the Constitution. An act of the National Assembly or regulation made thereunder cannot curtail or circumvent the filing of processes in that regard. Neither can it provide for the manner such processes should be signed, bearing in mind the provisions of the Legal Practitioners Act as amended in Section 2, Sub 1 and 24, Sub 1 thereof, and the rules of professional conduct meant for legal practitioners in paragraph 10 thereof. The issue relating to failure to state the second respondent's address in his petition has also been overtaken by the event of the amendment granted to the second respondent to amend his reply to the petition in the ruling of 24th of June 2019 as aforesaid. In the result, the petitioner's applicant's notice of preliminary objection succeeds on grounds 2 and 4 thereof, while grounds 1, 3, 5, and 6 of the objection fail and are dismissed. Now to the merit of this application. The type of the reply a petitioner can file pursuant to paragraph 16(1) A and B of the first schedule to the Electoral Act as amended have been statutorily regimented by the said paragraph, in that any reply to the respondent must not contain any requirements of paragraph 4 of the first schedule to the said act pertaining to the facts that ought to have been stated or pleaded or encapsulated in the contents of a petition. Filing of a reply by a petitioner is not an opportunity to add to the petition fresh facts or new issues which do not arise from the reply of a respondent to the petition. Reply to a respondent's reply to a petition by a petitioner must not contain facts that would tantamount to an amendment of the petition after the expiration of 21 days stipulated for filing of the petition, without due application for amendment of the petition. I refer to some cases. I've carefully examined paragraphs 1, Roman 1 to 23 of the second respondent's reply to the petition, and I am of the view that there is serious issue of jurisdiction against the hearing of fact relating to the relief sought in the petition and the entire reliefs sought in the petition. They are all new issues relating to the competence of the petition and the jurisdiction of this court to embark on the trial or hearing of the petition. The petitioners are entitled to be heard on the jurisdictional point and have the right to place facts in their reply to counter the position of the second respondent. It is consistent with their right of a fair hearing. And I made reference to a case which I cited. That's the case of Comrade Ajoke and Oye, decided last year, 2018, citation of which is provided. Therefore, the petitioner reply to the second respondent's reply to the petition, part 1, reply to the preliminary objection, paragraphs 1 to 18 thereof are valid and within the confines of paragraph 16(1) of the first schedule to the Act as amended. However, paragraph 19, 20, 20, 21, 22, and 23 of the said petitioner reply to the petition are new issues of facts which add to the content of the petition. The facts pleaded in the said paragraphs are part of the requirements of paragraph 4 of the first schedule to the Act. They are accordingly liable to be and are hereby struck out for violating paragraph 16(1) of the first schedule. Part 2 of the reply to the second respondent's, which the petitioner's objection to the second respondent reply has been determined earlier in this ruling. Part 3 of the petitioner reply to the second respondent reply to the petition treated what the petitioner styled I quote, petitioner reply to the second respondent reply on merit. I have carefully read the paragraphs of the second respondent reply to the petition, which the petitioner's reply to the petition sought to controvert. And I'm of the view that the paragraph 3, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 21, and 23 of part 3 of the petitioner's reply to the petition are on the merits are liable to be struck out because they constitute new facts which tend to amend or add to the content of the petition filed by them. There are no issues of facts in the second respondent's reply to the petition in paragraph 16, 22, 24, 25, 26, 27, 28, 33, 331, 332, 333, 334, 335, 336, 337, 338, 339, 340, 341, 342, 361, Roman 1 to 4, 362, Roman 1 to 9, 364, 381, Roman 1 to 4, 382, and 362, 380 thereof, which necessitate any reply to the second respondent's reply. All pleadings contained in the said paragraphs of the second respondent's reply are facts permitted in the reply to the petition, as stipulated in paragraph 12.1 of the first schedule to the Act as amended. The said paragraphs are therefore liable to be and are hereby struck out. Paragraph 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 of the petitioner's reply to the second respondent's reply are hereby struck out. The petitioner's additional list of documents in reply to the second respondent's reply to the petition contained in pages 15 to 18, and the petitioner's additional list of witnesses and witnesses' statement of Osita Chidoka and the witnesses' list in reply to the second respondent's reply all contained in pages 19 to 40 of the said reply, petitioner's reply, part 3 to the second respondent's reply are also hereby struck out as a consequence. My learned brother to my immediate right will now pronounce his decision in respect of this motion.
I agree.
My learned brother to my immediate left will now pronounce his decision in respect of this motion.
I agree.
My learned brother to my extreme right will now say his decision in respect of this motion.
I also agree.
And my learned brother to my extreme left will say his decision in respect of this motion.
I agree.
And the next motion is the second motion filed by the second respondent, which, like I mentioned earlier, was also filed on the 14th of May, 2019. And this is the leading ruling. The second respondent prays for the following relief in this motion: an order striking out and or dismissing this petition for being incompetent, fundamentally defective, and vesting no jurisdiction on this honorable court to adjudicate thereon. Further, or in the alternative to prayer 1 above, 2, an order striking out the paragraphs, several of them, which I set out, and 3, for such orders or further orders as this honorable court may deem fit to make in the circumstances of this case. The grounds in support of these prayers are 24, and I set them out. A 7-paragraph affidavit was filed in support of this application, along with the 38 pages written address. The petitioners, in reaction to the said motion, filed a counter affidavit consisting of 5 paragraphs, along which is attached a 23-page written address. And in the written address of the applicant, that's the second respondent, 6 issues were distilled and presented in this motion for decision. And I set them out. The Learned Senior Counsel for the petitioners also formulated 6 issues, which I also set out. The motion was taken on the 11th of June 2019, and I went on to consider the arguments of the Learned Senior Counsel for the parties. After a consideration, a review of all the arguments canvassed on all the 6 issues raised by the Learned Senior Counsel for the parties, I went on to determine the issues. And I began by saying that the petitioners are pleaded in paragraph 15 of their petition as follows. Paragraph 15, the petitioners state that the grounds upon which this petition is based are as follows. A, that the second respondent was not duly elected by a majority of lawful votes cast at the election. B, that the election of the second respondent is invalid by reason of corrupt practices. C, the election of the second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2010 as amended. D, the second respondent was at the time of the election not qualified to contest the said election. And E, that the second respondent submitted to the first respondent an affidavit containing false information. False information of a fundamental nature in aid of his qualification for the said election. The contention of the Learned Senior for the second respondent is that because the grounds set out above are disjointed and incompatible, they are liable to be struck out. Specifically, the second respondent argued that grounds 5, 15D, and E have become statute bar and not maintainable. The Learned Senior Counsel for the petitioners was quick to submit that a petitioner is entitled under Section 138 of the Electoral Act to present an election petition against the return of a respondent under one or more of the grounds contained therein. According to him, what the petitioner could not do in this case is that they cannot rely on Section 138(1)D along with other grounds in this section. Now, Section 138(1) of the Electoral Act provides as follows, and I set out the. And I went on to say that by the amendment, by the Electoral Act Amendment Act 2015, which came into effect on the 26th of March of 2015, Section 19 thereof amended Section 138(1) by the insertion of a paragraph D, which reads, and I quote again, that the person whose election is questioned has submitted to the Commission an affidavit containing false information of a fundamental nature in aid of his qualification for the election. Section 145(1) of the Electoral Act 26, which is very similar to the provisions of Section 138(1) A to D of the Electoral Act 2010 as amended, was interpreted by the Supreme Court in so many cases, including Atiku Abubakar and Umaru Musa Yar'Adua, which was decided in 2008, and Katsina Alu, JSC, later CJN, and of blessed memory, had this to say: an election petition is sui generis. That is to say, in a class by itself. Surely there's no longer a moot point. Surely this is no longer a moot point. It is different from common law civil action. This must be borne in mind throughout these proceedings. The applicable law under consideration is the provision of Section 145(1) of the Electoral Act 2006, which I've earlier on in this judgment set out, but for ease of reference, I hereby read it again, and His Lordship read it. It will be seen clearly that grounds A, B, and C above are separated from ground D by the word or. The word or is defined in Black's Law Dictionary, 6th edition, in the following terms. A disjunctive participle used to express an alternative or to give a choice of one among two or more things, end of quote. In the case of Barubo and Aileru, 1993, 3 NWLR, Part 280, 126, at 141 to 142, this court, in construing the word or, stated thus: the power given to the court under the rule is to either strike out or amend, the word or having a disjunctive connotation. It does not give the court the power to strike out and amend, end of quote. Also in the case of Abia State University and Anyebe, 1996, 3 NWLR, Part 439, 646, the Court of Appeal, Parkas Inaalu JCA, as it then was, held. It is to be noted that 12-month period is separated from the text from the next period by the word or. This word always bears the disjunctive meaning in an enactment. That is to say, it separates the provision preceding it from the proceedings coming after it. Its role is to show that the provision in which it is appearing are distinct and separate one from the other. In Black's Law Dictionary, 6th edition, the word or is defined inter alia, a disjunctive participle used to express an alternative or to give a choice of one among or two other things, end of quote. His Lordship continued, without a doubt, the word or in Section 145(1) of the Electoral Act has compartmentalized the grounds A, B, C, and D together, and the ground D on its own. There's good reason for this. A careful reading of Section 145(1) will reveal that a petition under Section 1A, B, and C does not presuppose that the petitioner did not in fact participate in an election as a contestant, whereas the petition under subsection 1D does propose that the petitioner was excluded from participating in the election as a contestant. I should imagine that the petitioner who did not contest an election would not be hard to complain that the election was invalid by reason of corrupt practices or non-compliance with the provisions of the Electoral Act, or that the respondent was not duly elected by a majority of lawful votes cast at the election. His Lordship continued and eventually concluded that the effect in law is that the petitioner claiming exclusion under Section 145(1)(d) of the Act is that he has shut himself out from presenting his petition under any of the grounds stipulated in Section 145(1), A, B, and C, as none of the grounds can still avail him, end of quote. Before the amendment of the Electoral Act in 2015, the Section 138(1), again came under consideration in the case of Oshomole and retired Ohiavere, Major General retired, which was decided in 2013. And His Lordship Mohammed JSC also made similar observations. I have no doubt in my mind that the petitioners are not disentitled or prohibited from presenting their petition on the grounds stated in paragraph 15A, B, and C, 15A, B, C, and D thereof, whenever the aforesaid grounds can be relied upon, along with paragraph 15E of the petition. Regard must, however, be had to the provisions of Section 285, 9, and 14 of the Constitution of the Federal Republic of Nigeria. I have considered and determined the competence of ground D and E in the petition as contained in paragraph 15 in the ruling on the first respondent's motion, which was decided before now. no practical or useful purpose will be served by mere repetition of the reasoning for the decision on the said grounds in this ruling. And it will suffice for me to say that for the reasons set out in the said ruling, issue 1 of the applicant, second respondent in this motion, is resolved against him. On issue 2, the central focus of the second respondent is that apart from the fact that reliefs 409 A, B, and C, A, B, C, and E are inconsistent or incompetent, there is no valid relief in paragraph 409 A, B, C, and D, or E, of the petition, and that the relief in 409F could not be adjudicated upon as an alternative, thus divesting this court of jurisdiction. The petitioners, on the other hand, are of the resolute view that there is no such inconsistency in the grounds of the petition and the reliefs being sought in paragraph 409F of the petition. Now, the settled position of the law is that when a claimant claims reliefs in the alternative, the duty of the court is to consider first or otherwise, to consider first the merit or otherwise of the main reliefs. It is when a court finds that the main relief fails or is not grantable that its jurisdiction to examine the merit of the alternative relief now comes into play. And I made reference to the case of Idifeco and Pfizer Products Limited, decided in 2014, and citation of which is set out. The relief F sought in the alternative by the petitioners is consistent with the settled position of this law. I stand by my finding on the issue 1 to the effect that the grounds contained in paragraph 15(1) A, B, C, D, and the reliefs in paragraph 401 A, B, C, and D are congruous and can be relied upon in a petition. This issue is hereby resolved against the second respondent. On issue 3, which has to do with whether this court ought to strike out the paragraphs containing allegations of use of smart card readers and electronic data purportedly retrieved from the first respondent server, on the ground that there is no law backing use of electronic voting or transmission of results via the card reader. I have reviewed the submissions of the learned senior counsel for the parties, and I'm of the firm view that the parties to the petition cannot run away or deviate from the numerous decisions of the Apex Court on the laudable use of the smart card readers in our electoral processes and whether electronic voting is an issue in our electoral process. Parties have joined elaborate issues on the use of the card reader and on the applicability or otherwise of electronic transmission of election results in the 2019 presidential election in their respective pleadings. The grounds upon which the petition rests are stated in paragraph 15 and the reliefs contained therein. The law is settled on how each of the grounds can be proved by the petitioner. Whether the petitioners will be able to succeed or establish grounds will be examined and determined when the court proceeds to consider the petition on the merit, if the application challenging the competence of the petition and jurisdiction of this court fail. What determines the jurisdiction of this court is not the pleading relating to server or card reader, but whether the court has jurisdiction to entertain the grounds upon which the petition is brought, having regard to the facts pleaded and the evidence led. This I have held under issue 1, and so the issue 3 is also hereby resolved against the second respondent. Issue 4 has to do with whether the paragraphs of the petition set out in paragraph 26, Roman 26 of the petition of the motion under consideration should be struck out for being vague, general, generic, nebulous, and lacking in particulars. Even though the second respondent alleged that the said paragraphs are not explicit and without particulars, yet the second respondent has joined issue with the petitioners on the assertions contained in the impugned paragraphs of the petition. I have calmly perused the said paragraphs of the petition, and I'm of the view that they are not nebulous, they are not generic, neither are they vague. I am of the view, however, that the onus is on the petitioners to establish the assertions of facts made therein or postulated in the said paragraphs. The issue 4 is therefore resolved against the appellant, against the respondent, second respondent, applicant. Issue 5 deals with the question whether the paragraphs of the petition wherein diverse allegations of crime and criminal wrongdoings were made against persons or individuals not joined as parties to these proceedings are liable to be struck out. The undoubted position of the law in both civil actions and in election petition is that any person against whom scurrilous and demnifying allegations of crime or criminal wrongdoing are made must be joined such that the person or persons are indispensable parties and they are necessary parties to the action if the court is to determine their guilt or not. The courts of the action will lack the competence and jurisdiction to make any pronouncement, particularly on criminal allegations on persons who are not parties to any election proceedings or any proceeding whatsoever. And like in the previous ruling, I made reference to some cases. I then went on to say that a close examination of the paragraphs 150, 228, and so many of them which are set out reveal that the allegation of the second respondents are true concerning the said paragraphs. The non-joinder of the persons or individuals who have been accused of serious criminal activities before and during the election is manifest in all the paragraphs which infringes their right to fair hearing for them to be maligned and accused of election offenses, as well as offenses criminalized under the Penal Code, to be heard in their absence as provided for in Section 361 of the Constitution of the Federal Republic of Nigeria. I'm not unaware of the argument of the learned senior counsel for the petitioners, who contended that the persons mentioned therein are agents of the second and third respondent, and that the Army and other security personnel or agencies mentioned in the petition are agents of the second respondent. And so the second and third respondent, as their principal, are liable or responsible for the action of the persons accused of criminal interference with the electoral process. However, I have pointed out in an earlier ruling that in law, there is no there's no vicarious liability in criminal law. The submissions of the learned senior counsel to the petitioners, therefore, is not sound in law. I again make reference to the case of APC and PDP, where Fabi again said it is basic that there is no vicarious liability in the realm of criminal law. Anyone who contravenes the law should carry his own cross. At page 127 of the said case, APC and PDP, Ogumbi JSC also had this to say. Their joinder about the petition will appear to have stemmed from a misapplication of the principle of vicarious liability, which is applicable only in civil matters, as opposed to allegations of commissions of crime, which have been made against a disclosed principal. See Adjoye and Olorinje, 1996, SC 5256 at 262, where it was held that it is not the law that a master is responsible for the crime of his servant, end of quote. See also Yesem and Wike, the case decided in 2016, citation of which is provided. The identified paragraphs of this petition are therefore liable to be, and accordingly hereby struck out for being incompetent. Issue 6 deals with whether this court had jurisdiction to entertain allegations contained in paragraph 368, 369, 370, 371, and 372 of the petition, which the second respondent claims have to do with government policy and non-joinder of Professor Yemi Osinbajo, SAN. There is no doubt that the aforesaid paragraphs of the petition raised criminal allegations of corrupt practices against the respondent and indicted Professor Yemi Osinbajo, SAN, who was not joined as a party to these proceedings. The petitioners had accused him and the second respondent of inducing voters with government funds not appropriated or approved by relevant authorities. I agree with the learned senior counsel for the second respondent that this court has no power to try any person on alleged spending of government funds not appropriated or approved for the purposes it was allegedly expended. The offending paragraphs of the petition, which I have mentioned, and which are paragraphs 368, 369, 370, 371, and 372, are hereby struck out. In the final result, this motion succeeds partially only in respect of issues 5 and 6 of the motion paper. The motion fails in respect of issues 1, issues 2, issue 3, and issues 4 of the motion paper, which are hereby dismissed for lacking in merit. My learned brother to my immediate right will pronounce his decision in respect of this motion.
I agree.
My learned brother to my immediate left will now say his decision in respect of this motion.
I agree.
My learned brother to my extreme right will now say his decision in respect of this motion.
I agree.
And my learned brother to my extreme left will also pronounce his decision in respect of this motion.
I agree.
Now we go to the third respondent. I don't know. This is the work file on the Tribunal. No? Yeah, look at that. Look at character rules. Seven rising for all the judges. Hello, you got this motion? File of petition. We check. What 15? File on the 15th. Check of me. List of issue. 15. Okay. Gentlemen, I now deal with the third respondent's motion. He also has two motions. I'll begin with the one filed on the 15th of May 2019. And this is the lead ruling in that motion. The motion seeks the following release from the court. An order granting leave to the third respondent to move and argue this application before or outside during the pre-hearing session. An order striking out this petition together with the petitioner's list of documents to be relied upon in this petition and the list of the petitioner's witnesses filed on the 18th of March for being incompetent and in gross violation of Section 2 and Section 24 of the Legal Practitioners Act, as well as the Electoral Act 2010 as amended. An order striking out the grounds D and E of the petition and the associated/related facts contained in paragraph 383 to 409 of the petition. And an order striking out the underlisted paragraphs of the petition, that is, and I set them out, also seeks for an order striking out the underlisted paragraphs of the petition for being imprecise, nebulous, and for failure to state the particulars of the polling units where the alleged infractions took place. 6, an order striking out paragraphs so and so, which allege harassment, arrest, and intimidation by the Nigerian police and Nigerian army when the agencies were not joined as parties to the petition. 7, an order striking out the underlisted paragraphs of the petition which challenge violent acts, which allege violent acts and intimidation against named individuals who are not joined as parties to the petition. 8, striking out paragraphs set out in the petition in that they deal with information supplied, propriety of information supplied by the second respondent in Form CF-001, which is a pre-election course of action within the context of Section 31(5) and 6 of the Electoral Act as amended, and Section 285(14)(b) and Section 285(9) of the Constitution of the Federal Republic of Nigeria, 1999, as amended, Fourth Alteration Act number 21 of 2017, and statute. 9, an order striking out paragraph 15(b) and (c) of the grounds of the petition, and also paragraphs 107 to 363 of the petition on acts alleging non-compliance with the Electoral Act, as well as paragraphs 364 to 387 of the petition on corrupt practices for failure of the petitioner to seek any relief based thereon, based on the two aforementioned grounds. 10, an order striking out grounds paragraph 15E and paragraph 409E of the petition for being outside the contemplation of Section 138(1) of the Electoral Act as amended and outside the jurisdiction of this Honorable Court, sitting as a court of first instance in a presidential election petition. 11, an order striking out paragraphs 389 and 390 of the petition, which pleaded Section 31(1) and 2 of the Electoral Act as amended, contrary to the rule of pleading, forbidding the pleading of law. And lastly, 12, an order striking out the petition as presently constituted for failure to comply with the mandatory provisions of paragraph 4 and 7 of the first schedule to the Electoral Act 2010 as amended and Section 134, 2A and B of the Constitution of the Federal Republic of Nigeria, 1999 as amended. The application is premised on 24 grounds, which I set out. It is also supported by a 32-paragraph affidavit as well as a written address. From the written address, the Learned Senior Counsel for the third respondent submits now a single issue, even though there are two. But the relevant issue is whether the prayers of the applicant in the present application should not be granted considering the circumstances and contents of the petition, vis-à-vis the mandatory provisions of the Electoral Act 2010 as amended, the Legal Practitioners Act, and the Constitution of the Federal Republic of Nigeria 1999 as amended. While the petitioners, in reaction to the application, filed a notice of preliminary objection on the 20th of May 2019. It is dated 19th of May 2019, and it reads as follows. I set out the objection. The Land Senior Counsel for the parties adopted the addresses on the 11th of June 2019. Now, the law is settled. The settled position of the law is that the issue or contention that a process or an action is an abuse of court is intertwined with the jurisdiction of the court, seat of the matter. In other words, a court or tribunal has no jurisdiction to entertain a process or a motion or notice or application which borders on abuse of court process. The court is enjoined to put an end to any process or steps taken by any party to a proceeding, and which the court determines to be an abuse of its process in limine, in order to protect the sanctity of the court or the tribunal. We'll refer to the case of Dingyadi and INEC, where Chukwumaene, JSC, stated, the term abuse of court process connotes simply the misuse of the court process, and it includes acts which otherwise interfere with the course of justice. Clearly, the acts include where, without reasonable ground, a party institutes frivolous, vexatious, and oppressive actions, and also by instituting a multiplicity of actions, or is on a frolic act of forum shopping, that is, seeking for favorable court to entertain a matter. It also includes depriving the court of jurisdiction. Arising from such acts, the court has the power to treat the act as contemptuous of the court, which can, apart from resorting to its use of coercive power of contempt, can also order the action to be stayed, as has been done herein in this appeal, or to dismiss it. It is also tried that where a preliminary objection is filed for the termination of the process or a matter in a proceeding, the court is enjoined or required to consider its merit first before delving into the merit of the process being challenged in the notice of preliminary objection. And I made reference to the cases on this point. It is therefore necessary for me to consider the petitioner's objection to the motion, and I've earlier reproduced the objection of the petitioner. The substratum of the petitioner's position on the preliminary objection could be found in paragraph 1.3 to 1.6 of the written argument, which runs thus, and I set it out. And after a consideration of the arguments on the preliminary objection, I said that the Land Senior Counsel for the parties have stated very correctly the principle of law relating to abuse of court processes in judicial proceedings. It is an established practice in litigation for a party who discovers that he has filed a defective process, particularly in interlocutory applications or matters, to file a better or corrected one before the date fixed for the hearing of the application which he conceives to be in default or defaultive. It behoves on such a party to apply to the court for the withdrawal of the objection of the defective process to enable him proceed with the later process which he considers to be correct. A respondent or a party to a proceeding A respondent, a party to such application, can ask for cost if he filed a counter affidavit or any other process against the process sought to be withdrawn. As rightly submitted by the learned senior counsel for the third respondent, a party can file two similar motions or applications before the same court, but has to withdraw one at the time of hearing before he proceeds with the other one. In the case of Ani and Efiok, decided in 2017, citation of which is set out, the Augie JSC said, the respondents also say it is an abuse of court process for the same reason canvassed for the preliminary objection. Let me quickly reiterate the point I made, that the applications are not barred by filing this application to give life to the appeal. The argument that the earlier application must be withdrawn before the applicant can bring this application lacks merit. There is no rule of law or practice that stops a party from filing an application when a similar application is pending in the file. The practice in court is that a previous application can be withdrawn before the fresh application is moved or thereafter, end of quote. The above being the position, the third respondent cannot, in the circumstances, be accused of abuse of court or judicial processes for the mere filing of this application. It will be recalled that when the motion filed on the 15th of May 2019, to which this objection has now been raised, when it came up for hearing on the 11th of June 2019, the learned senior counsel to the third respondent, Prince L.O. Fagbemi SAN, applied to withdraw the motion filed on the 14th of May 2019, which is similar to the one to this particular motion, and it was eventually withdrawn and struck out. This court then struck out the said application before the application under consideration was moved. In the result, the application or the notice of preliminary objection filed on the 20th of May against the third respondent's motion dated and filed on the against this motion is hereby dismissed for lacking a merit, for being misconceived. The third respondent's motion will now be considered on the basis of the issues submitted for decision by the learned senior counsel. Issue 1 is as to whether this is a proper application to be heard and determined during pre-hearing session, which has been overtaken by the argument of the motion. The learned counsel, I'll proceed to issue 2, or would deal with prayer, whether the petition filed on the 18th of March is competent, and whether some of its grounds and paragraphs ought to be struck out for violating the Electoral Act 2018 and the first schedule thereto. Learned counsel will recall that I have dealt with issues, all the issues, in fact, in this motion, in the earlier application filed by the first and second respondent, dealing with the competence of this petition, as well as the paragraphs mentioned in this petition. There will be therefore no need for me to repeat myself and the reasoning contained for the decision in the said motions. However, specifically, for failure to make all the persons, organizations, individuals mentioned in the paragraphs of the petition already identified in prayers 6 and 7 of the motion paper, render this court incompetent and without jurisdiction to adjudicate or determine all of them. All the said paragraphs of the petition are hereby struck out. With regard to the prayer to strike out paragraphs 388, 389, 390, 391, 392 to 404 of the petition, with regard to whether the border on pre-election and caught by the Fourth Alteration Act of 2017 or 2015 to the Constitution, I stand by my reasoning on the grounds that paragraph 15D and E of the petition are valid grounds and therefore competent to thereby vest this court with the requisite jurisdiction to entertain this petition. Prayer 8 is refused. In respect of prayer 9, seeking for striking out of paragraph 15B and C, and paragraph 107 to 363 of the petition is also not well-founded. I have earlier on found that these paragraphs are competent paragraphs. The petitioners are entitled to rely on paragraph 15B and C as grounds founding this petition. Once again, I refer to the case of Shomole and Ariaveri, reported in 2013. In the final result, the motion succeeds partially in terms of the prayers 6 and 7 only, and fails in respect of all the other prayers as indicated earlier. My learned brother to my immediate right will pronounce his decision in respect of this motion.
I agree.
And my learned brother to my immediate left will pronounce his own decision in respect of this motion.
I also agree.
My learned brother to my extreme right will say his position in respect of this motion.
I agree.
My learned brother to my extreme left will pronounce his own decision in respect of this.
I agree.
Gentlemen, before I take the second motion by the third respondent, this application filed by the petitioners challenging the reply of the third respondent to which his second motion relates. This motion by the petitioners should come and be taken first before the second motion by the third respondent. So I'll deal with the ruling in respect of the motion by the petitioners, which was filed on the 13th of May, 2019, challenging the competence of the third respondent's reply to the petition. This is the leading ruling. The motion seeks the following reliefs. A, an order striking out the entire reply of the third respondent to the petition for being grossly incompetent. Or in the alternative, B, an order striking out paragraphs 1, 2, 3, 4, 5, and 6 of the third respondent's reply to the petition for being extraneous to the petition and thus incompetent. There are 4 grounds upon which the prayers are premised, and it's supported by an affidavit deposed to by Jedidia Daudu. The third respondent, as it was to be expected, filed a counter affidavit and a written address on the 20th of May, 2019, to oppose the application. The learned senior counsel for the petitioners, in his written address, submitted 4 issues which he said called for determination in this motion. And I will read them. 1, whether the reply of the third respondent to the petition is competent in the absence of the National Identity Number, NIN, of counsel who signed the reply shown or reflected on the reply as mandatorily required by the provisions of the mandatory use of National Identification Number Registration Regulations 2017. 2, whether the challenge of the qualification of the first petitioner to contest the presidential election raised in the reply of the third respondent to the petition, which was filed outside the 21 days stipulated for the filing of an election petition, is not stated bare. 3, whether the qualification of the first petitioner to contest the presidential election of February 23, 2019, can properly be raised in the third respondent's reply to the petition. 4, whether the contention of the third respondent that the first petitioner is not qualified to contest the presidential election on 23rd of February 2019, not having been supported by any relief, is rendered incompetent for being hypothetical, academic, and speculative. And he argued those issues. For the third respondent, 2 issues are raised in the written address, and they are as follows. Whether the petitioner's instant application as constituted, challenging the competence of the third respondent's reply to the petition is competent and proper before the Honorable Court. And 2, having regard to the peculiar circumstances of this petition, whether the petitioner's motion seeking to strike out the third respondent's reply to the petition or the instant application is meritorious and grantable. And learned senior counsel went on to argue their issues. And after a consideration of the arguments by the learned senior counsel, I went on to determine the merit of the application. And I started with saying, by a mere glance or visual observation of the signature on the motion paper and the signature on the written address accompanying the motion paper shows similarity in the 2 signatures, indication the motion paper and written address were signed by the same person. And I find that the motion and the written address were signed by one and the same person. And I find that under Section 101(1) of the Evidence Act as amended, and the authority of FCMB PLC against CP Tech Construction Company Limited, a case decided in 2015 and citation set out, empowered this court to compare signatures and form an opinion on them. The written address has the tick name of counsel that signed it and his MBA seal identified as Jude Daniel Odi Esquire, showing both the motion paper and the written address were signed by an identifiable legal practitioner, Jude Odi Esquire, whose name can be traced to the role of legal practitioners. Both processes are therefore competent in this petition. The application is titled Motion on Notice, and it has prayers in form of reliefs stated on page 1 thereof, and the grounds upon which the application is based is also contained on page 2 thereof. It is therefore not a notice of preliminary objection. Paragraph 47 of the first schedule to the Electoral Act entitles any of the parties in an election petition to file an application by way of formation or notice in these words, and I set them out. The petitioners being parties in this petition are therefore entitled to file the present motion or notice. Paragraph 47(2) of the first schedule to the Electoral Act uses the permissive word may in respect of filing an affidavit in support of the motion. Consequently, unless an affidavit is necessary for the application by way of a motion or notice, the party filing the motion need not file an affidavit in support of a motion. The third respondent cannot therefore be right in the submission that every motion must be supported or must have a valid affidavit in support of soft motion before the motion will be competent. In my opinion, paragraph 3 of the affidavit in support of the application contains statement of facts not extraneous to the matter by way of objection, prayer, or legal argument or conclusion, and does not offend it does not offend section 1152 of the Evidence Act. The objection to the said paragraphs of the affidavit in support of the motion is accordingly untenable and is hereby rejected. Now, Regulation 11U made pursuant to NIC Act provides thus: in accordance with the provisions of section 27(1) of the Act, the use of the national identification number shall be mandatory for the following additional transactions: U, filing and registration of criminal and civil actions in courts and other arbitration processes. The Supreme Court, like we pointed out in an area ruling this morning, in the case of Marafa, APC and Marafa, cited by the third respondent, in relation to Section 27 of the NMIC Act and regulations made thereon, held thus, and I repeat again, Section 27 of the National Identity Management Commission Act 2007 and its regulations are not part of the rules of this court and cannot therefore apply to the proceedings filed in this court. Clearly, I find no merit in the preliminary objection. Accordingly, same is hereby overruled. End of quote. The first leg of the relief supply in the motion paper seeking to strike out the third respondent reply to the petition for violating the NMI Act or failure to insert the national identification number of the third respondent senior counsel that signed it is therefore untenable and is hereby rejected. Paragraphs 1, 2, 3, 4, 5, and 6 of the third respondent's reply of the petition read thus, and I set them out. Then paragraph 12(2) of the first schedule to the Act provides, and I quote, where the respondent in an election petition complaining of undue return and claiming the seat or office for a petitioner, or petitioner intends to prove that the claim is incorrect or false, the respondent in his reply shall set out the facts or figures clearly and distinctly disproving the claim of the petitioner, end of quote. What this paragraph provides for is the requirement of pleading, joining the respondent to set out, enjoining the respondent to set out facts and figures frontally, distinctly, and clearly disproving the claim of the petitioners upon which the petitioners are challenging the return of the second respondent as the winner of the election. The facts and figures sought to be disproved by the reply are therefore those that are tied to the averments in the petition on why the second respondent should not have been returned as elected. It is difficult to appreciate how the qualification of the first petitioner to contest the election would add value or impact to the traverse of the third respondent in the third respondent reply against the petitioner's grounds with respect to the return of the second respondent, who was sponsored by the third respondent in the said election, under challenge in the present election petition. Instructively, it was held by this court in the case of Idris and AMPP 2018 and 2008, citation of which is set out. Sanusi again, JCA, as he then was, has stated, this time I quote him briefly, it goes without saying, therefore, that if the appellant wanted to use the ground of qualification of the second petitioner for whatever reason, it had to file a cross petition and not to use such alleged non-qualification of the second petitioner as a defense, end of quote. Section 138(1)A of the Electoral Act also states, an election may be questioned on the ground that the person whose election is questioned was at the time not qualified to contest the election. The person whose election is complained of is by Section 137(2) of the Electoral Act referred to as the respondent, while Section 239(1) confers on this court the jurisdiction to determine whether the person has been duly and validly elected to the office of the president or vice president, thus limiting and circumscribing the jurisdiction of the court to the issue whether the person whose election is questioned was validly elected. It does not extend to determination of whether any of the petitioners who is challenging the election or return of the respondent was qualified to contest the election. The fact that the petitioner pleaded that the first petitioner had the right to be voted for and return in the election to the office of the President of the Federal Republic of Nigeria would not enlarge the jurisdiction of this court under Section 239 of the Constitution, which, along with Section 137(2) and 138(1)(a) of the Electoral Act, as parties cannot and do not, even by consent or acquiescence, confer jurisdiction on the court. I made reference to some cases. It is accordingly my view that the issue of qualification or disqualification of the first petitioner to contest the election is only a ground for challenging the election of the person returned, the second respondent hearing, and not a defense or a reply to the petition. In the result, I find substance in the second and alternative leg of the motion paper, impugning paragraphs 1, 2, 3, 4, 5, and 6 of the petition, which is hereby granted, and the said paragraphs of the third respondent reply to the petition, challenging the qualification of the first petitioner to have contested the election in question, are accordingly hereby struck out. I also made reference to the case of Adiogun and Fashogbon Supra. In conclusion, this motion succeeds only in respect of the second arm of the relief sought, which is hereby granted, while the first arm of the relief, which is not made out, is hereby refused and it is dismissed. My learned brother to my immediate right will pronounce his own decision in respect of this motion.
I agree with the ruling just delivered on this motion.
My learned brother to my immediate left would also say his decision in respect of this motion.
I also agree.
My learned brother to my extreme right will now say his own position in respect of this motion.
I agree.
My learned brother to my extreme left will also pronounce his own decision in respect of this motion.
I agree.
Gentlemen, I now deal with the second motion filed by the third respondent on the 14th of May, 2019. And the motion primarily prays for the following reliefs or orders. An order of this Honorable Court striking out Part A of the petitioner's reply to the third respondent's reply to the petition, dated and filed 18th of April 2019, for being incompetent and in violation of the mandatory provisions of the Electoral Act 2010 as amended. It also seeks an order of this Honorable Court striking out paragraphs 1 to 21 of Part B of the petitioner's reply and or entire petitioner's reply to the third respondent's reply to the petition, dated and filed on the 18th of April 2019, for being in gross violation of the mandatory provisions of the Electoral Act 2010. Also seeks an order of this Honorable Court striking out all the witnesses' statement of oath filed together with the petitioner's reply to the third respondent's reply to the petition, for being irregular and in flagrant non-compliance with the relevant provisions of the first schedule to the Electoral Act 2010 as amended. And the prayers are premised on 15 grounds which are set out. And the motion is supported by a 26 paragraph affidavit, as well as a written address. The petitioners oppose the application and file a 6-paragraph counter affidavit, to which is also accompanied a written address. In the written address, the third respondent submitted these issues for consideration, 2 of them, and they are whether this is not a proper application, no, okay, to be heard and determined by this honorable tribunal before or outside during the pre-hearing session, and 2, whether the petitioner replied to the third respondent replied to the petition dated and filed on the 18th of April 2019 and or the offensive paragraphs therein, together with all the accompanying statements of oath and the purported preliminary objections embedded therein are not incompetent and liable to be struck out in the entire circumstances of this petition. On their part, Line Senior Counsel formulated also a single issue, which is whether the said averments reply and the accompanying written statement offend the provisions of section of paragraph 16(1)(a) and (b) of the first schedule to the Electoral Act 2010 as amended and are liable to be struck out. Went on to consider first the objection by the applicant to the motion. And then I went on to discuss and determine the sole motion in the motion. After a consideration of all the submissions on the objection as well as the merit of the application and the issue raised, I went on to say that the real issue in controversy in this application is whether the petitioner's reply to the third respondent reply to the petition dated and filed on the 16th of April violates paragraph 16(1)(a) and (b) of the first schedule to the Electoral Act, which provides thus, and I set it out. A petitioner, by the above provision, in reply to the respondent's reply to the petition, shall not include or bring in new facts which are capable of amending or adding to the contents of the petition. The petitioner's reply must not introduce any of the requirements of paragraph 4b of the said schedule. The petitioner is also prohibited by paragraph 16 aforesaid from introducing pleadings that would infringe paragraph 14(1) of the first schedule to the Act. Otherwise, the reply will be treated as void and liable to be struck out. This is because the Electoral Act 2010 does not permit a petitioner to hide under the guise of filing a reply to a respondent's reply to the petition to set up a different case from what he already had relied upon in the petition. And I made reference to some cases in respect of this. I have calmly scrutinized the petitioner's reply to the third respondent's reply to the petition, particularly Part A, dealing with the preliminary objection. And I'm of the view that paragraphs 1 to Roman 1 to Roman 18 thereof do not offend paragraphs 16(a) and (b) of the first schedule to the Electoral Act, as all the paragraphs contained in the third respondent's reply to the petition, paragraph A, notice of preliminary objection, raised new issues of facts in defense of the petition, which the petitioners have not dealt with in their petition. In respect of Part B of the reply to the third respondent's reply, the petitioners raise objections to paragraph 1, 2, 5, 1, 2, 3, 4, 5, and 6 of the third respondent reply, contending that the matters relating to the qualification of the first respondent ought to be by way of a formal petition within 21 days after the date of declaration of the result, and that the said paragraphs touching on qualification cannot be done by a reply. This issue has been resolved in the ruling just delivered in the petitioner's motion of 13th of May 2019, challenging the said paragraphs of the third respondent's reply to the petition, dealing with the petitioner's qualification to contest the election in question. For reasons set out in the said ruling, the said paragraphs of the third respondent's reply to the petition on the qualification of the first petitioner to contest the election remain and are hereby struck out once again. The petitioners, under their aforesaid objection in Part B of the petitioner reply, submitted that the third respondent reply is incompetent because the learned senior counsel who signed the reply has no name number shown or reflected on the reply in breach of the NIMC Act. I am of the view, as held by the Supreme Court, that the same regulations do not apply to proceedings filed in this court. And this issue has been decided in a ruling by this court on the 24th of June 2019 in the second respondent's motion to amend his reply to the petition, and in the ruling just delivered on the motion filed on the 14th of May 2019 by the second respondent on the authority of the case of APC and Senator Kabir Marafa and others. Now, the filing and signing of court processes are governed by Section 2, 1, and 24 of the Legal Practitioners Act. The objection to the petitioner's prayer 1, 2, 3, 4, and 5 of Part B of the third respondent's petition is therefore lacking in merit and it fails. In respect of paragraph 5 to 21 of the petitioner's reply to the third respondent's reply under Part B, pages 5 to 11 of the reply, it is necessary to compare the paragraphs with paragraph 16(1)(a) of the first schedule to the Act in order to determine if, in fact, they contravene the said paragraph of the first schedule. In my view, it is my view that paragraph 5, 6, 7, 8, 9, and 11 of the said paragraph of this petitioner's reply to the third respondent's reply, Part B, are within the contemplation of paragraph 16(1)(a) of the first schedule to the Electoral Act, as they were necessitated by new issues of fact raised by the third respondent in the reply to the petition. However, a close perusal of paragraphs 10, 12, 13, 14, 16, 17, 18, 19, 20, and 21 of the reply, they are clearly outside the precinct and contemplation of paragraph 16(a), 1A and B of the first schedule to the Act. But they are in gross violation of the said paragraph of the first schedule to the Act. The paragraphs 10, 12, 13, 14, 15, 16, 17, 18, 20 to 21 of the petitioner reply tantamount to bringing in new issues, new grounds, and prayers tending to amend or add to the contents of the petition. These paragraphs for violation of paragraph 16(1)(a) and B of the first schedule to the Electoral Act are liable to be and are hereby struck out. At the same time, all the paragraphs of the witness statement on oath filed together with the petitioner's reply to the third respondent's reply to the petition are consequently struck out insofar as they touch on the paragraphs which were struck out in Part B, which have now been struck out for being in contravention and breach of paragraph 16, subparagraph 1, A and B of the first schedule thereof. My learned brother to my immediate right will pronounce his decision in respect of this motion.
I agree.
My learned brother to my immediate left will say his decision in respect of this motion.
I agree.
My learned brother to my extreme right We will now say his decision in respect of this motion.
I agree.
Amalane brother to my extreme left will also pronounce his own decision in respect of this motion.
I agree.
Gentlemen, at this juncture, we will take a very short break to refresh and then come back. The break will be very short.
Where is
Take this one. This was soon followed by a series of applications by the parties which have been dealt with and in respect of which ruling have been delivered by this court this morning. The hearing of this petition commenced on the 4th day of July, 2019, when the petitioners opened their case. They called a total of 62 witnesses and closed their case on the 19th of July, 2019. The first respondent, through its senior counsel, Yunus Ustaz Usman Ezean, informed the court that he would rely on the evidence of the petitioner's witnesses, since, according to him, the evidence proffered supports its defense to the petition. The learned senior counsel to the second respondent, Chief Wole Olanipekun Ezean, opened the defense of the second respondent on the 30th of July, 2019, and called 7 witnesses in support of the defense of the second respondent. The second respondent's case was closed on the 1st of August. On his part, Prince Elo Fagbemi, Ezean, learned senior counsel for the third respondent, also informed the court on the same day that the third respondent, like the first respondent, would rely on the evidence led by the petitioners for the third respondent's defense, as according to him, enough evidence has been elicited under cross-examination of the petitioner's witnesses. In addition, Ranad Selk also said that the third respondent stated it will rely on the testimony of the witnesses called by the second respondent. The court ordered the parties to file their written addresses, all of which were duly filed and exchanged between the learned senior counsel for the parties. And it will be recalled that on the 21st of August, the final addresses were adopted by learned senior counsel for the parties. The learned senior counsel for the petitioner for the first respondent, in his written address, final address, nominated 4 issues, which he says call for determination in this petition. And I quote him: A, whether, having regard to the evidence before this honorable court, the petitioners have been able to establish that the second respondent was not duly elected by a majority of lawful votes cast at the election. B, whether the petitioners, by their pleading and evidence, have been able to establish that the election was invalidated by reason of corrupt practices. C, whether there exists sufficient evidence for the court to hold that the election of the second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act. And lastly, D, whether the petitioners have established the alleged non-qualification of the second respondent and given false information, end of quote. The learned senior silk for the second respondent formulated 3 issues which he says require determination in this petition. And I quote 2. 1, having regard to the clear provision of Section 131 of the Constitution of the Federal Republic of Nigeria 1999 as amended, stipulating the qualification for election to the office of President, as well as the known antecedents and pedigree of the second respondent, whether the petitioners have been able to make any case that the second respondent was not qualified to contest the presidential election held on the 23rd of February 2019, and or that he submitted false information to the first respondent in his form CF-001. 2, considering the pleadings of the petitioners and the added evidence proffered by them, whether the petitioners have not woefully failed to prove any of the allegations of non-compliance with the provisions of the Electoral Act 2010 as amended, corrupt practices, and that the second respondent was not duly elected by majority of lawful votes cast at the presidential election on the 23rd of February 2019. And lastly, 3, considering the feeble case presented by the petitioners before this honorable court, whether the court can decree that the first petitioner was duly and validly elected as President of the Federal Republic of Nigeria at the presidential election held on the 23rd of February 2019. On his part, the learned senior counsel for the third respondent also identified 6 issues in his final address, which he says require determination in this petition. And I quote him too. 1, whether in the circumstances of this petition, the petition is competent, and whether the paragraphs which the third respondent is objecting to are regular and valid. 2, whether the second respondent was at the time of the election not qualified to contest the said election. 3, whether the second respondent submitted to the first respondent an affidavit containing false information of a fundamental nature in aid of his qualification for the election. 4, whether the petitioners have proved the allegation of corrupt practice in the conduct of the election into the office of the President of the Federal Republic of Nigeria beyond reasonable doubt. 5, whether or not the presidential election held on the 23rd of February 2019 was conducted by the first respondent in substantial compliance with the provisions of the Electoral Act 2010 as amended, the guidelines and manual for election officials 2019. And lastly, whether the second respondent was duly returned with a majority of lawful votes cast at the election into the office of the President of the Federal Republic of Nigeria held on the 23rd of February 2019. Dr. Livy Uzoku-Ezean, lead counsel for the petitioners, in the final address, raised 5 issues for determination in this petition. And they are as follows. 1, whether the second respondent was at the time of the election not qualified to contest the election. 2, whether the second respondent submitted to the first respondent affidavit containing false information of a fundamental nature in aid of his qualification for the said election. 3, whether from the pleading and evidence led, it was established that the second respondent was duly elected by majority of lawful votes cast at the election. 4, whether the presidential election conducted by the first respondent on the 23rd of February 2019 was invalid by reason of corrupt practices. And lastly, 5, whether the presidential election conducted by the first respondent on the 23rd of February 2019 was invalid by reason of non-compliance with the Electoral Act 2010 as amended, the Electoral Guidelines 2019, and the manual issued for the conduct of elections, end of quote. The same issues were raised in the petitioner's final written address in reply to the final address of each of the respondents to the petition. I am of the view that the issues formulated by Dr. Livy Uzoku-Ezean for the petitioners represent the complaints and the grounds upon which this petition is brought and can be utilized for the determination of the petition. And the said issues will be considered in sequence and order they were argued by the learned senior counsel for the petitioners, as well as the other counsel for the respondents. I went ahead to do so. There are several arguments canvassed in respect of issues 1 and 2 by all the learned senior counsel for the parties. I'll go to the resolution of the issues 1 and 2, canvassed by the parties. The petitioners have pleaded in paragraph 388 to 405 of their petition that the second respondent does not possess the requisite educational qualification to contest the presidential election conducted on the 23rd of February 2019, and that he had submitted to the first respondent an affidavit containing false information of a fundamental nature to aid in aid of his qualification for the said election. In view of the enormity of the time and energy devoted to the allegations of the parties in this petition and the submissions by the learned senior counsel, the broad spectrum provisions of the Constitution, the Electoral Act 2010 as amended, it is in the interest of justice to reel out the entire pleadings of the petitioners relating to issues 1 and 2 under consideration. And I did. I set them out. I will now have resort to the Constitution and the Electoral Act as amended on non-qualification and disqualification of the second respondent to contest the February 2019 election. The reason is that it is said that the Constitution and the Electoral Act, the reason is that it is the said Constitution and the Electoral Act that govern matters or issues relating to qualification and grounds for presentation of an election petition on the ground that a candidate is not qualified to contest a particular election. The court will be guided in the interpretation of the provisions relating to the qualification in the said Constitution and the Act by decided cases. The Supreme Court has settled that when it comes to qualification to contest an election, recourse must be had to the provisions of the Constitution of Nigeria and the Electoral Act as amended. In the case of Ucha and Onwe, decided in 2011, citation of which is set out, Tabai JSC stated, and I quote him, "It was, in addition to the petitioner's first respondent, also relied on Emero and Duru, 2004-9 Nigeria Equal Law Report, Part 877, page 75, and Abana and Obi, 2005-6 NWLR, Part 920, at page 1 to 3. In Emero and Duru, the case of the first respondent was that he was duly nominated by his party, screened and cleared, and indeed contested the election of 16th April 2003, and won and was duly issued with Form EC8E1 by the returning officer. Thereafter, the second to third respondent purported to cancel, withdraw, and invalidate the said Form EC8E1 and declared the appellant winner of the said election. The first respondent therefore filed a petition at the Election Tribunal which gave him judgment and granted the relief as follows. The appeal to the Court of Appeal was dismissed. In the concluding paragraph of the lead judgment, at page 106 of the report, 5B JCA, as he then was, concluded. In conclusion, this appeal is devoid of merit. The appellant who did not contest an election cannot be returned. He has no seat in the House of Representatives. It is clear from the report that the petitioner actually contested the election and won. He was issued a certificate of return, and the substitution on the petition was predicated, and the substitution on which the petition was predicated was made after the election. The matter, therefore, was clearly a post-election matter over which the Election Tribunal had jurisdiction. In the circumstance, I hold that the authority does not support the principle postulated by the counsel for the first respondent. I've also read a banner on OB cited by the Learning Council, and I cannot say without any equivocation that the case has no bearing whatsoever upon the issue of proper venue for a pre-election or post-election dispute. The Learning Council, for the first respondent, made further reference to provisions of Section 246(1)(b)(1) of the Constitution on appeal to the Court of Appeal. His Lordship went on. And concluded that the result of both analysis is that the appeal has merit and should be and is hereby allowed. The nomination and substitution of the first respondent upon which the petition was predicated was clearly a pre-election matter over which only the Federal High Court or State High Court has jurisdiction. Then in INEC, in PDP and INEC, 2014, as I mentioned, Okoro JSC said, as I mentioned earlier, a person who wishes to challenge the election on the basis that the winner was not qualified to contest the election has an umbrage under Section 138(1)(a) of the Electoral Act. That is to say, where a person failed to take advantage of Section 31(5)(6) in the High Court, he can still approach the Election Tribunal under Section 138(1)(b). Now, Section 177 of the Constitution of the Federal Republic of Nigeria. Well, that is Lordship continue. Sections 131 and 137 of the Constitution of the Federal Republic of Nigeria, which are relevant in this petition, as amended, are as follows. And I set them out. A person shall be qualified for election to the office of President if A, is a citizen of Nigeria by birth, B, he has attained the age of 40 years, C, he is a member of a political party and is sponsored by that political party, and D, he has been educated up to at least school certificate level or its equivalent. Section 137(1). A person shall not be qualified for election to the office of President if, subject to the provisions of Section 28 of this Constitution, he has voluntarily acquired citizenship of another country other than Nigeria, or except in such cases as may be prescribed by the National Assembly, he has made a declaration of allegiance to such other country, or B, he has been elected to office at any other two previous elections, or C, under the law in any part of Nigeria, he is adjudged to be a lunatic or otherwise declared to be of unsound mind, or D, if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or a fine for any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed on him by any court or tribunal, or substituted by a competent authority for any other sentence imposed on him by such a court or tribunal. E, within the period of less than 10 years before the date of the election to the office of President, he has been convicted and sentenced for an offense involving dishonesty, or he has been found guilty of the contravention of the Code of Conduct. Or F, is an adjudged bankrupt, having been adjudged or otherwise declared bankrupt under any law enforced in Nigeria or any other country. Or G, being a person employed in the civil service or public service of the Federation or any state, he has not resigned, withdrawn, or retired from employment at least 30 days before the date of the election. Or H, he is a member of any secret society. Or J, he has presented a false certificate to the Independent National Electoral Commission. Subsection 2, where in respect of any person who has been adjudged a lunatic, declared of unsound mind, sentenced to death or imprisonment, or adjudged a declared bankrupt, any appeal against the decision is pending in any court of law in accordance with any law enforced in Nigeria. Subsection 1 of this section shall not apply during the period beginning from the date when such appeal is lodged and ending on the last day when the appeal is finally determined, or, as the case may be, the appeal lapses or is abandoned, whichever is earlier. Subparagraph 3 of Section 137(1) of the Constitution says, a person who was sworn in as president to complete the term for which another person was elected as president shall not be elected to such office for more than a single term. End of quote. Now, Section 318(1) of the Constitution defines what the term school certificate or its equivalent mean as provided under Section 31. It provides thus: school certificate or equivalent means A secondary school certificate or its equivalent, or grade 2 teacher certificate, the city and guild certificate, or B, education up to secondary school certificate level, or C, primary 6 school leaving certificate or its equivalent. I, or that should be Roman 1, service in the public service, in the public or private sector, in the Federation, in any capacity, acceptable to Independent National Electoral Commission for a minimum of 10 years. And 2, attendance at courses and training in such institutions as may be acceptable to the Independent National Electoral Commission for periods totaling up to a minimum of 1 year. And 3, the ability to read, write, understand, and communicate in English language to the satisfaction of the Independent National Electoral Commission. And D, any other qualification acceptable by the Independent National Electoral Commission. End of quote. The petitioners have argued strenuously that failure by the second respondent to attach the certificate listed in Form CF001 to this form means that the second respondent does not possess the certificate he claimed in Part C of the said form about the schools attended or the educational qualification with dates, and that evidence of all educational qualification should be attached. The second respondent stated in the said column that he attended primary school and has primary school certificate in 1952, that he has secondary education and was in 1961 for his higher school. He stated officer cadet 1963. There is no evidence before this court to show or prove that the second respondent lied that he went to the primary school, secondary school, or that he joined the army in 1962 with RW1 and many other persons in the second respondent's CV attached to Exhibit 1, which was the form FCF001 attached to the second respondent name, which was submitted to the first respondent. The Exhibit P1 tendered by the petitioners at page 1 thereof shows conclusively that the second respondent attended primary school and that he attended Katsina Provincial School, now Government College in Katsina, between 1956 to 1961, and went to Nigerian military training from 1961 to 1963. The evidence of RW1 and RW2 also bear testimony to the aforesaid fact. The said RW1 and RW2 established beyond doubt that the second respondent had educational qualification, which had stated his educational qualification in Form FC001 on the 18th of October 2018. The learned senior counsel for the petitioners had argued that the evidence led to prove the second respondent attended primary school, or that he attended some courses is irrelevant because he did not rely on any of those qualifications in Exhibit P1. With respect to him, the argument is faulty because the Form CFO001, which is admitted as Exhibit P1, specifically asked the second respondent the school he attended with qualification attained or obtained in order to determine whether the second respondent has attended or have been educated up to at least school certificate level or its equivalent, which is part of the qualifications stipulated in Section 131 of the Constitution of the Federal Republic of Nigeria. The petitioners have also relied on Sections 76 and 31(4) of the Electoral Act 2010 as amended, and that it is compulsory for the second respondent to attach evidence of qualification to Exhibit 1. Section 31(4) of the Electoral Act provides, and I quote, "Any person may apply to the Commission for a copy of nomination form, affidavit, and any other document submitted by a candidate at an election, and the Commission shall, upon payment of a fee prescribed, issue such a person with a certified copy of the document within 14 days. The above section of the Electoral Act does not say in any way that a document or school certificate or certificate of qualification be attached to the said form. In any event, Section 31(4) of the Electoral Act must be read together with Section 31(2) of the same Act, which says, I quote, "The list or information submitted by each candidate shall be accompanied by an affidavit sworn to by the candidate at the Federal High Court or High Court of the State or Federal Capital Territory, indicating that he has fulfilled all the constitutional requirements for the election to that office. The reasonable inference and plausible meaning attachable to the above provision of the Electoral Act as amended is that a candidate can list information concerning evidence of his qualification or other relevant information about him. The demand or information required in Exhibit 1 cannot be more or higher than the statutory requirement. Section 76 of the Electoral Act, as amended, provides the forms to be used for the conduct of election under this Act shall be determined by the Commission. Where the provisions of the statute is straightforward and unambiguous, the court cannot read anything into the statute what it does not contain. The statute must be succinctly read, must be thoroughly interpreted in a manner that will project and bring out succinctly the real intention of the lawmakers. No extraneous matter should be allowed to stray into the principle of interpretation of an act or the Constitution. The cases referred to, in my view, the provisions of Section 76 of the Electoral Act is clearly inapplicable to the issues under consideration. The form referred to in the said section are the forms to be used in the conduct of an election as the Form Exhibit A has been taken care of in Section 31 of the Electoral Act, and the said exhibit is tied to the steps laid down in the said Section 31 of the Electoral Act. More importantly, the law is firmly settled that a candidate is not required by the Constitution or the Act to attach his certificate to Form CF001 before the candidate can be considered or adjudged to have the requisite educational qualification to contest the election. For instance, in the case of Kaki and PDP, decided in 2014, citation of which is set out, Galadima JSC has stated that the contention of the appellant that the fourth respondent was not qualified to contest the election because of non-presentation of his certificate. However, the court below recognized the fact that the issue of non-qualification of the fourth respondent by virtue of non-presentation of his certificate was never the case of the appellant from the beginning, as earlier observed. The appellant has contended that, having regard to Sections 182(7)J of the Constitution, the fourth respondent is necessarily required to present his certificate to the first and second respondent in order to prove his qualification to contest the election. Otherwise, he is disqualified under Section 177D of the Constitution, and that by Section 167D of the Evidence Act, the failure is fatal because if produced, it would have been unfavorable to him. This contention is misconceived. Submission or presentation of a certificate is not the requirement of Section 177D of the Constitution as regards the gubernatorial screening process. The process of screening which the appellant and the fourth respondent undertook with the first respondent requires that the candidates to fill in his qualification in the form and to swear to a verifying affidavit that the information contained in Form CF001 was true. This takes away the necessity of presentation of actual certificate to the first and second respondent. When the appellant was confronted under cross-examination with Exhibits C and D, the nomination form, which is similar in form with INEC Form CF001, and with the first respondent used in screening the appellant and the fourth respondent, he stated that he did not attach his certificate to his party nomination, form, and that he did attach his certificate to his primary nomination form, party nomination form, and that the same procedure of not attaching certificates to the nomination form applied to all candidates. He admitted that presenting or submission of certificate was not a requirement for the purpose of screening. See page 1711, volume 1 of the record. In any case, his lordship continues, it is not a requirement of Section 177D of the Constitution for the candidate to necessarily present the certificate to qualify for election to the office of governor of the state. By the provisions of Section 177D of the Constitution, a person shall be qualified for election to the office of governor of the state if D, he has been educated up to at least school certificate level or its equivalent. By Section 138(1), school certificate or its equivalent means B, educated up to secondary school certificate level. In Bio and in JIDA, 2004, 8 NWNR, Part 876, 544 at 630, 2004 FWLR, Part 192, page 10 at 78, the Court of Appeal, then the apex and final court on election petition, Assembly/Governorship and Legislative Houses Election Tribunal, had this to say on the point, and his lordship courts the presentation or the holding by the Court of Appeal. In other words, as regards a secondary school certificate examination, it is enough, in my view, that one attended school certificate level, that is, without passing and obtaining the certificate, end of quote. His lordship continued, by the combined reading of Section 177D and Section 138B of the Constitution, it is not only the requirement or basis, which is not the only requirement or basis for qualification, but the candidate has been educated up to secondary school level. I am on an agreement with the Learned Council for the respondent that it is not only by presentation of certificate of the respondent that is the only proof that the fourth respondent is qualified as the appellant here, who has taken his disposition and did not by his own showing under cross-examination present or submit one. As rightly held by the court below, by Section 131 to 134 of the Evidence Act, it is only by cold facts presented to the law court that the civil rights and obligations of the parties are determined. By dint of these foregoing sections of the Evidence Act, Learned Council would do well for the litigants, who would be happier if they shun sentiments, as this command no place in judicial deliberations. See Ogbiti and NAOC Limited, 2010-14 NWLR, Part 1213, page 208. A litigant must be able to establish his case on the evidence he presented before the court or on known and settled principles of law. In sum, the appellant having failed to show that the concurrent findings of fact by the lower court is perverse, thereby occasioning miscarriage of justice, I cannot disturb the same, and the conclusion that the appellant's claim is frivolous, brought malafide, vexatious, the end of quotation. See also the case of Olatunji and Wahid, decided in 2010, citation of which is set out. The provisions of the Electoral Act cannot subvert the clear provisions of Section 131, 137, and 138(1)(d) of the Constitution of Nigeria as amended. Any allegation of giving false information and affidavit submitted to INEC must be false information of a fundamental nature that breaches any of the provisions of Section 131, 137, and 1381D of the Constitution of the Federal Republic of Nigeria. The petitioners insinuated that the officer candidate is not a qualification or certificate under the Constitution or the Electoral Act. The Oxford Advanced Learners Dictionary of International Students Edition, 7th edition, described cadet as a young person who is training to become an officer in the police or the armed forces. There is evidence on record by RW2 and RW3, 4, and 5 that the second respondent has secondary school education at Katsina Provincial Secondary School, now Government College Katsina, from where he proceeded to Nigerian Military School, Kaduna, from Form 6 in 1962, along with RW1. In effect, the second respondent went through education in the military after his secondary school education. The military training is though higher than secondary school certificate education. The petitioners in paragraph 3.43 in their address, 3.43 in their address, in response to INEC final address, submitted that the second respondent gave false information, which he claimed in his affidavit deposed to on the 24th of November 2014, and submitted to the first respondent via Form CF001 on the 18th of October 2018, when he said all his academic qualification documents as filed by him in the presidential form were with the Secretary Military Board as at the time he made the affidavit. The petitioners also said that they have proved that they have proved false affidavit, and in addition, they pleaded and tendered public statements by the Secretary to the Army Board, both in electronic and print media, and also relied on exhibit P80 and P24 to show that the Army emphatically denied the claim, and as such, the onus of proof has shifted to the second respondent to disprove the claim. The fact remains that the second respondent did not call the Director of Army Public Relations, Brigadier General Olajide Olaleye, who they pleaded in paragraph 396 of the petition as having debunked the assertion of the second respondent in the affidavit sworn to on the 24th of November 2014. The said paragraph 396 constitutes the fountain and pivot of the petitioner's allegation, and they have the duty to show that the affidavit contained false information of the fundamental nature in aid of his qualification for the election. What the petitioners did through the council was to tender documents from the bar with no one to confirm the authenticity of the report contained in exhibit P80 and P24, and with no witness to cross-examine on it, thereby rendering these exhibits of no probative value, as the court cannot rely on them at the fountain and found in favor of the petitioners. The consistent holding of the Apex Court is that such documents must be tendered through their makers, or where tendered from the bar, the maker or a witness with knowledge of the exhibits must be called to give evidence on them. More so, the petitioners made allegations of crime the cornerstone of issues 1 and 2 in this petition. In the case of Ikpeazu and Oti, 2016, citation of which we set out, Galadima again once said, "It is set in law that a party who did not make a document is not competent to give any evidence on it. This is the situation where PW19 did not make exhibit PWC2. She cannot competently tender it. The maker must be called to testify to credibility and veracity." See also the case of Wike, Yesem, and Peterside, the case of Emmanuel and Umana. But that is not the end of the matter. The matter goes further. And even if exhibits 24 and 80 are admissible exhibits which can be used in this petition. PW can be accorded probative value and weight. The newspaper in exhibit P22, P24, and in particular, the statement or refutation by Brigadier General Olajide Olale on the 21st of January 2015 does not at all support the position of the petitioners that the second respondent has no certificate or that he was not educated up to secondary school certificate level, as the exhibit is point blank on this issue. The exhibit P24, point blanks, confirms that the second respondent obtained a WAS certificate, otherwise known as West African School Certificate, and that he attended the schools listed in exhibit P1. I will reproduce in full the statement of the Army made under the title, Army Speaks on Buhari Certificates, by one Kingsley Omonobi. The whole report, the complete report, reads, and I quote, Abuja, as controversy continues to trail the academic qualifications of the presidential candidate of All Progressive Congress, APC, Major General Muhammadu Buhari, the Army yesterday said it was not in possession of Buhari's credential. The APC presidential candidate, Major General Buhari, had averred in an affidavit he deposed before an Abuja High Court that all his certificates were with the Secretary Military Board while submitting his Form 199A to the independent, is from CF001 to the Independent National Electoral Commission, INEC. But the Army yesterday denied being in possession of the APC's candidate's original certificate or the certified true copies. The outgoing Director of Army Public Relations, Brigadier General Olajide Laliye, who addressed newsmen in Abuja, said, and he quotes, "The Nigerian Army does not have the original copy of his, Buhari in bracket, West African Certificate Council, WAEC result, or a certified true copy," end of quote. The report continues, but the APC, in a swift reaction, has warned that those who are bent on destroying Buhari on the basis of his certificates may end up destroying the country's military. The Army spokesman, who told newsmen that the Army had, and which he displayed, were information contained in the forms Buhari filed at the point of his entry into the military, and some letters of recommendation by a principal of the Provincial Secondary School, Katsina. For the record, Olajide said, records available indicate that Major General Muhammadu Buhari applied to join the military as a Form 6 student of the Provincial Secondary School, Katsina, on October 18, 1961. His application was duly endorsed by the principal of the school, who wrote a report on him and recommended him as suitable for military commission. The report, which was shown to newsmen, read, and there's a quotation in quote, "I recommend Muhammadu Buhari fit for military commission," end of quote. On Buhari's result, the principal also wrote, and I quote again, quote in quote, "I considered that he will pass math, English, and 3 other subjects," end of quote. Laleye said the briefing was necessitated by the deluge of requests from civil society groups and the media, among others, over General Buhari's ineligibility for any political office. He continued, he said, "It is a practice in the Nigerian Army that before candidates are shortlisted for commissioning into the officers' cadre of the service, the selection board verifies the original copies of credentials that are presented. However, there is no available record to show that this process was followed in the 1960s. Nevertheless, entries on the Nigerian Army Form 199A at the point of documentation after commission of an officer indicated that the former head of state obtained the West African School Certificate, WASC, in 1961 with credit in relevant subjects: English language, geography, history, health science, Hausa, and a pass in English literature. Olale continued, neither the original copy, certified true copy, CTC, no statement of result of Major General Muhammadu Buhari's WASC result is in his personal file. What I have said here is what is contained in his service record personal file. We have not added or subtracted anything. Earlier, Brigadier General Laye has said, "Let me state clearly that the Nigerian Army holds the retired senior officer in very high esteem and respect and will not be a party to any controversy surrounding his eligibility for any political office." Suffice it to state that Major General Buhari rose steadily to the enviable rank of Major General before becoming the head of state of our dear country in December 1983. End of quote. This statement apparently, clearly, unequivocally confirms that the second respondent actually obtained West African School Certificate and passed credit in 5 subjects in 1961 in English language, geography, history, health science, Hausa, and also a pass in English literature. The statement confirmed the truism and authenticity of exhibits R19, R20, 21, R22, and R23 tendered by the second respondent through witnesses RW3, RW4, and RW5. What Brigadier General Olajide Laye said is that the original copy or the CTC or a copy is not in his personal file. This does not exclude the inference that the Army may have the certificate, having regard to the fact he stated, which I again repeat. Nevertheless, the entry made on the Nigerian Army Form 199A at the point of documentation